Okay, welcome back. We're going to continue our Cram course review, part 2. We finished off on unit 8 on part 1. So we're going to continue on unit 9. And unit 9 is about title, deeds, and ownership restrictions. Okay, you're going to have 7 questions on your exam. So 7% of the test will come from unit 9. So the first thing about title is you want to know the difference between legal and equitable title. So what's legal title versus equitable title? Okay, legal title is a legal concept signifying ownership to the collection of the rights called a freehold estate, right? You have the freehold estate, and then that's held 2 different ways, fee simple or a life estate. An equitable title is when an individual will receive legal title at a future date. A buyer receives this upon executing a contract prior to title closing. So this is like when you have a seller that's holding the mortgage and you pay the seller, they're going to hold the title until you pay it off. When you pay it off, you get the title. That's called equitable title. Okay.
Yep.
And a few words that you need to know. Some explaining the various methods of acquiring title to real property. So how is this done? So the first thing is alienation. Alienation is the act of transferring ownership, title, or an interest in real property. Alienation may be done 2 ways, right? Voluntary and involuntary. So voluntary will be with the owner's control and consent. Involuntary is without the owner's control and consent. So let's look at the differences. Okay, so ways to transfer by voluntary alienation. You can use a deed and a will. A deed will be a written instrument that's created to use to convey the interest in the real property, and that conveys legal title. Convey means takes from the seller to the buyer, right? It transfers it. A will is done in 2 ways. So, the way a will is done is it's called testate. That's when a deceased person prepared a will before their death. And you have the testator. Okay, the testator is the person who leaves a will. Okay, real property is transferred to the devisee. So the person inheriting it is a devisee. The person leaving it is a testator. And when you have a will, it's called testate.
Quick question.
Mm-hmm.
The word devisee, where does it come from?
I don't know where it comes from. I don't know. If you look at the history of it, I mean, you can see where it came. But a devisee is receiving in a legal term. I would think it probably comes from Latin, like a Latin, legal term.
Yeah, well, I'm not referring to like all the way back then when it was invented, but more just just like testator will be, the one leaving the testate. So it comes from the word testate.
Yeah.
I was just trying to see, what the device is.
It's legal terminology. I would think it comes from Latin language. I mean, testate, testator, devisee would be the person getting it. I just always known it as that. I've never thought about it too deeply. I just took it for what it was and what it is.
Got it.
Yep.
No problem.
Okay, now when it comes to involuntary without the owner's control, that's something like when it's a tax sale, foreclosure, things like that, right? That'll be involuntary. Now, what we want to do next is we want to differentiate between voluntary and involuntary alienation. You need to know these. So voluntary alienation is the act of transferring ownership, title, or interest in a real property with the owner's control and consent. Again, that's through a deed and a will, right? A written instrument that conveys a title, and the same situation with the will. Involuntary alienation is an act of transferring ownership, title, or an interest in real property without the owner's control and consent. Okay, this would be called, one way is through descent, one is through a cheat to the state, and one is adverse possession. Okay, descent means it goes to the heirs. That's when a person dies without leaving a will. Somebody dies without leaving a will, it goes to their heirs. That's called intestate. With the will's testate, without the will's intestate. You have escheat to the state. That's when a person dies intestate. That means they had no will and they have no heirs. Okay, that's when the state will take the property. And adverse possession occurs when the property is seized from the true owner who sleeps on his rights. Okay, adverse possession, we'll talk a little bit more about that in a second here. But that's when someone, if a house is abandoned, they can go in, they can take over the house, pay the taxes, pay the bills, and they can actually have the court over after so much time, give them the house. They can actually get the house. So next would be describe the conditions necessary to acquire real property by adverse possession. And the acronym is HOTCAN. And that would be the conditions for adverse possession. There has to be a hostile possession, open possession. So basically the house, they have to take the house. If nobody's in, they got to go in it. Okay, open possession, let the world know they're there. Taxes got to be paid by the adverse possessor, and they can put a claim on title. The adverse possession has to be for 7 years. So they got to live in there for 7 years, pay the taxes, pay the bills, and basically it's called notorious and flagrant public possession. So adverse possession is a law that states if property is abandoned, if somebody goes through this process, they can take the property. The court will give them the property. Okay, then you have eminent domain. This is where government power to take property for a public purpose by legal process called condemnation. So you got to remember, condemnation is the process that the government uses to issue eminent domain, right? It's called condemnation, is the process. Okay, there's just compensation. That means the property gets appraised and the government pays the people the appraised value. It's got to be for a public purpose. Remember, condemnation is the process through the court. And it's a judicial or administrative proceeding to exercise the power of eminent domain. The court will exercise that.
Quick question. What is the difference between escheat and eminent domain?
Okay, escheat is you die and there's no heirs for the property and the state takes it. It doesn't cost them a penny. Eminent domain is you're living in your house and they decide to put a highway through. And it's going to be public land and you have no say in it. It's for the public good. And they're going to got to go through and they got to appraise all the houses and pay the people the money to take the land to put the highway.
Got it. Okay.
Got it?
Yes, sir.
Okay. Distinguish between actual notice and constructive notice. You got to know the difference, right? So actual notice is direct knowledge acquired in the course of the transaction. You're there, you witnessed it, you saw it be signed, right? That's actual notice. Constructive notice is legal notice. Okay, that's when you record the document in the public records and the world sees it, it's public. And then there's an acknowledgement, okay? A formal declaration before a notary public by a grantor that the signing is a free act. No one was forced. So when you sign a deed, there's two witnesses and the seller. And the notary is notarizing it, saying that there was no ill will, there was nothing, out of the ordinary. There was no forced sale, right? The next topic for Unit 9 is you want to be able to distinguish between an abstract of title and a chain of title, and explain the different types of title insurance. So a chain of title is a complete successive history all the way back in time to when it was deeded. An abstract of title is a search of recorded documents. It's a condensed history. So it just goes through all the transfers and all the documents. A title opinion is executed by an attorney who has studied the abstract. It's an opinion of whether the title is marketable if there's any issues with it. And it's usually not guaranteed. It's just an opinion of what they see if there's any problems. Okay, licensees as agents and brokers are not qualified to give opinion of title. You cannot give opinion of title. It has to come from an attorney. Okay, and the types of title insurance. You have an owner's policy, and a lender's policy. Okay. The owner's policy is issued for the purchase price. It protects new owner and owner's heirs. It's not transferable to another owner, and it's a one-time premium. The lender's policy is issued for the mortgage loan amount. It protects the lender against title defects. It's transferable, which means it's assignable. It protects lender up to the current outstanding loan balance. And most lenders require as a condition of making a loan. If you don't have a lender's policy, they will not give you the funds for the loan in most cases. And it's a one-time premium paid at closing. The lender's policy is transferable because when one lender sells the mortgage to another lender and the owner just changes who they're paying, nothing changes but the payment. That policy has to transfer as it sells. Okay. Now let's describe the parts of the deed and the requirements of a valid deed. Okay, there's two parties of a deed. You have the grantor, who is the owner giving title. They must be competent, must sign a deed, and there must be two witnesses to verify. The grantee is the new owner receiving title. They do not have to be competent. The name must be on the deed. And the owner, the grantee does not sign the deed. Only the grantor does. Okay. And the parts of the deed. Okay, there's the premises. It contains the name of the grantee and grantor. The consideration is in exchange for the title, the amount. Granting clause states the grantor's intention to transfer the title to the grantee. The legal description of the property. The appurtenances are rights and privileges transferred with the property. The habendum clause defines the bundle of legal rights being conveyed. The covenant or season promise, the covenant of season promises that the grantor has the right to convey it. It simply states the seller has the right to sell the property. Okay. Season clause says they can sell the property. And the signature of two competent grantors. The signature of the competent grantor or grantors and two witnesses. Okay, that's the parts of the deed. And the requirements of a valid deed is, one, it has to be in writing, which is required by statute of frauds. Names of the grantor and grantee. The grantor is of legal capacity. Consideration must be described. The granting clause, the words of conveyance. Again, the legal description. Signed by the grantor and two witnesses. And last but not least, it has to be voluntarily delivered and accepted by the grantee. It has to be accepted. Okay. Now, let's list and describe the four types of statutory deeds and legal requirements for those deeds. So there's a quitclaim deed. Okay, this is used in divorce or probate situations. Basically, the grantor releases his interest, if any. The grantor does not warrant the title. They don't guarantee anything. It provides a lease protection for the grantee. There's only a granting clause. And this is used to clear clouds on title, which means if there's misspellings or something simple. Basically, it remisses what's done. There's a release and a quitclaim to fix it, right? That's the process. Then you have the bargain and sale deed. Okay, this is used in foreclosures and tax sales. So if you see bargain and sale, you think foreclosure, tax sale, right? Or you're getting a bargain. Okay, there's a granting clause, a habendum clause, and a season clause. The grantor does not promise to defend title, and there's no future warranty. It conveys all the title that the grantor has, but it does not protect the grantee from clouds or claims on the title. So what that means is there's no title search done. You're buying a house at auction, you need to do your own research. There's no judgments and claims. If there's judgments and claims and you buy that house, you now take on those judgments and claims. So you need to do your own research when it comes to this type of deed, right? And this type of process. Okay, and this is used in foreclosure and tax sales. Okay. Then you have a special warranty deed. Okay, remember, special is usually focused in. General is everything. Remember that on your exam. So special warranty deed, and remember, it's used often in commercial. The grantor will only defend the title during the grantor's ownership. So from the time the seller bought it till now, they'll defend that. There's a granting, a habendum, and a season clause. And the grantor did nothing to encumber or cloud title during the grantor's ownership. That means there was no judgments, no liens, nothing that they did during their ownership. And a general warranty deed is used in most residential transactions. It contains all covenants and warranties available. The granting, the habendum, and season clause, quiet enjoyment, peaceful possession, undisturbed by claims of title. Further assurance, the grantor will deliver legal instrument if required. And the warranty is forever, okay, to defend against grantee's title. So from the day you buy it, the warranty is forever going back, not forward, of course, because anything can happen in the future, but going back, right? Go ahead.
What does it mean by further assurance? Like what legal instrument would the grantor deliver if required?
If there's anything they need, like if there was something that came up, they would deliver any legal instrument to say there's no cloud, no issue, anything from the history of the property at all.
Okay.
And then this is required if the sales contract does not state a type. So if the agent doesn't put a type on the contract, if both agents don't put the type of title, this is going to be required. It'll be this type of title automatically. Okay. Now, we need to list and describe the various types of government and private restrictions on ownerships of real property and distinguish among the various types of leases and liens. Okay, so there's 3 governmental limitations on ownership of the properties. And the acronym is PET. You have police power. Okay. E is for eminent domain. That's a typo there. I have to fix that. So it's eminent domain. And T is for taxation. So police power is the broadest power of government to limit owners' rights. They do this by zoning ordinances, building codes, and health ordinances. So if they want, they limit the property's rights by putting certain zoning. This can only be residential. This can only be industrial, right? They limit you. So, because if that rule wasn't there, you could do whatever you wanted, right? Building codes, there's certain structure and building codes in Florida that Florida has that other states don't because of hurricanes and things like that, right? And health ordinances, health codes and things like that. So they control through police power ownership, right? Eminent domain. That's the taking of property for public use for just compensation. They got to pay you. The condemnation is the process, right? But they control land by that, right? They control ownership by that. And taxation. Property taxes is a primary basis for local taxation. You don't pay your taxes, see how long you have your home, right? You could pay your home off. You could have no mortgage, but don't try not to pay your taxes, right? So they control that. Now, private restrictions on ownership. Acronym is DEL. These are deed restrictions, right? One is D is deed restrictions. So you have deed restrictions versus restrictive covenants. They're 2 different things, okay? So deed restrictions are private restrictions placed in a deed, and it will affect the use of one property, right? So remember I talked about, like, if I own a restaurant and I buy a building across the street and I'm moving my restaurant to that building and I own the building where my restaurant is, I can put a deed restriction that you cannot put a restaurant in this building for 100 years. So the new buyer buying it would have to accept that. They accept that, nobody's putting a restaurant there for 100 years. That's a deed restriction. It's for one property and the owner does it. Then you have restricted covenants. Okay, so unlike deed restrictions, restrictive covenants are recorded by the developer along with the plat map. And that affects all the properties in the subdivision. Like when you go into certain subdivisions, you can't have commercial vehicles with lettering on them, right? That is like a restrictive covenant. So you have to park that in the garage, right? You could not have it out in the driveway. That's something that's recorded when the plat map is approved and, for the development. Do you understand the difference of that?
Yeah, definitely.
Then you have easements, okay? Easement is the right to use a portion of an owner's land for a specific and limited purpose. It does not convey ownership, okay, or possession. Okay, examples include utility easements, railroad rights of way, and ingress and egress easements. So the types of easements, you have an easement appertuit. Okay, this benefits a specific parcel of land adjacent to another. You have an easement in gross. This benefits an individual or a business entity, like a utility. So, there's so many feet in the back that have to be empty. You can't put a fence up like on each property so trucks can get through and things like that, right? And an easement by prescription. Okay, this occurs when someone uses another property for a certain amount of time without permission in a way that the owner should be aware. Okay, the time limit is 20 years open and continuous uninterrupted use. That means if, you have a driveway that's on the neighbor's property and you're driving through and it's been there for 20 years and no one says anything, that easement will be an easement by prescription because you use that, right? And no one said anything. You don't own it. It's just you're using it, right? And an easement by necessity would be a landlocked property. That's a property that has land all around it and there's no way to enter it. So they would give an easement through another property so you can get to it. You wouldn't own the property, but you would be able to go through that and use that to get to your property. Okay. Now let's talk about leases. Okay. Lessors grant right of possession to use the lease to the lessee. That's the tenant. So lessor is the landlord. The lessee is the tenant. They grant the right of possession and use for a term. Right? They don't transfer ownership interest. They give a leasehold estate, right? You have the time to lease it and it's your property for that term, right? You have the right to an enjoyment, right? Leases of more than 1 year must be in writing and signed to be enforceable. Signed by the lessor, lessee, and 2 witnesses if more than 1 year. Licensees may use fill-in-the-blank lease forms approved by the Florida Supreme Court to assist them in completing them. And let's talk about the types of leases, right? You have the gross lease. That's where the tenant pays fixed rent, $1,500 a month. That's it. You have a net lease. That's where a tenant pays fixed rent plus the property cost. That would be the taxes or the insurance, maintenance, things like that. A percentage lease. That's where the tenant pays rent based on the gross sale received. So they pay a fee and then they pay a portion of their profits over a certain amount or a portion of the profits. Variable lease is when a tenant pays a specified rent and it increases at future dates. So if you get a 10-year lease and you pay $1,000 a month first 2 years, $1,200 the second 2 years, $1,400, it'll increase. That's a variable lease. And a ground lease is a long-term lease on land only, and a tenant will erect buildings on the leased land. That's like if you hear the places leasing like a 100-year lease for $1, and then they build a building on it or whatever they do. That's just an example, right? I think where like the casinos down in Hollywood, like they leased that land for a very long time, very cheaply, and then they built multi-million-dollar casinos on it, right? So things like that. They give land leases, ground leases, right?
That's a great business.
Yeah. Assignment and sublease. Okay. You have an assignment of lease. This is when a leasee assigns to another person all of the lease property for the remainder of the lease. That's like a business owner has a lease and he sells the business to somebody. They take over the lease. That's an assignment, right? Owner has to approve that, right? You can't just do it. And then you have a sublease, and that's used to give only part of the lease. There's 2 ways to sublet. The tenant assigns a portion of the lease property, like an office within a building, or a tenant assigns all the property for less than the remaining term of the lease. So you have 5 years left. You lease it to somebody for 4.5 years. They take it, they pay it. You're still responsible. And then they move out and you go back in before you give it back. That's the 2 ways to sublet. Okay. Now let's talk about liens on property. Okay. A lien is the right to have a debt satisfied out of the properties owed by the debtor. So if the owner of the property is sued or owes money, you could put a lien on the property to be paid. The lien holder is the lienor, may have the property sold to pay the debt of the owner, the lienee. Okay, liens are recorded in the public records. Now, when they're recorded, that's constructive notice, right? Good. Liens are encumbrances. Other encumbrances include easements, deed restrictions, and government regulations. Okay, you have voluntary and involuntary liens. Okay, so a voluntary lien is with the consent of the owner. Mortgage lien or a vendor's lien. Vendor's lien is like if you're having the roof replaced for 15 grand, you give them 5 grand up front, they do the work. Usually a roofing company will put a $10,000 lien, and then when the roof is finished and you pay them, they remove it. That's how they guarantee getting paid, right? And then involuntary is without the owner's consent. That would be like a judgment lien. That would be like a tax lien, construction liens, like if you had an addition put on and didn't pay the guy. Mechanics lien, construction lien, same thing. And you also have general and specific liens. Okay, so general liens are not restricted to one property. So if you own 5 properties and you have a general lien against you, they can attach all properties. That would be a judgment lien, like if you get sued, an IRS lien, income tax lien if you didn't pay your taxes, and a federal estate tax lien. Okay, if you inherited stuff and you owe taxes, they can actually attach the properties if you don't pay. Specific liens applies to a specified property. So if you don't pay your taxes on one property, your property tax, they can only put a lien on that property. They can't attach other properties. Special assessment lien for that property can only be on that property. That's like paving the roads. Remember how we did that, the math problem dividing? Mortgage lien. If you have a mortgage on one property, they can only have a lien on that property. Vendor's lien. Again, if they're fixing the roof on that property, they can't put that lien on a different property. It has to be on that property. And a construction mechanics lien. That's if you had a deck put on and didn't pay the guy. They can go and put a lien on the property. Okay. I have somebody I know actually just, they painted a house and they made an agreement to pay them when the house closes. So he put a lien on their property until they pay them. So the lien means they have to pay them at closing or they won't be able to sell the property. That's an example.
Amen. Question for you. So for those scenarios when a vendor would put a lien on a property, that has to be acknowledged and like kind of agreed to prior to them doing the work.
Not agreed to, as long as our contract says it in it and you sign the contract.
Okay.
Right? So that's going to be in the contract. They got to explain it to you. But hey, if you want me to do this work, this is what happens. This is how it works, you know?
Gotcha.
Yeah. Okay. Number 10. Unit 10 is on legal descriptions. In legal descriptions, you have 5 questions on the test. It'll be 5% of the examination for the state. Okay, so legal descriptions. So what you need to know in this section, one is you have to be able to describe the purpose of legal descriptions and understand the licensee's role and responsibilities as it pertains to legal descriptions. Okay, they're used to describe the property in a way that uniquely identifies them from any other partial. A survey is a drawing of a partial showing its boundary lines, the outside boundaries. Licensee should take care to insert legal descriptions into sales contracts from a reliable document, such as a deed or check the property appraiser's website. It's very important because if the property description is not accurate, a good attorney can void the contract. Okay. So let's describe the process of creating a legal description using the meets and bounds method. So remember, meets and bounds is the oldest one, right? Oldest one known to man. It has a point of beginning, right? It's the oldest one. It has an exact reference starting point. It starts at the point of beginning, and the first boundary is determined from the legal description that indicates the direction and distance of the first corner of the partial, and so on. Corners of the partial and point of beginning are identified with fixed markers called monuments, right? Monuments for the oldest one, right? It begins with either north or south, followed by a number of degrees up to 90 degrees. The direction that follows the number of degrees indicates whether the direction is east, west, of due north, or south, like north 45 degrees east. That's an example. Directions are given in degrees, minutes, and seconds. So it'd be like north 45 degrees, 25 minutes, and 20 seconds east. And it uses compass directions. There's a little diagram of the directions and the degrees, right? Okay, so now let's look at locating a township by township lines and ranges. So you have to remember the horizontal, which is the east and west township line, they're every 6 miles apart. Remember, east and west, every 6 miles. It starts at the baseline, right? The baseline and 6 miles north, 6 miles south, over and over. The 6 mile wide horizontal east-west strips are called tiers or townships. So you have your baselines and you have your townships, right? I'm sorry. You have your baseline and then you have your townships east and west. I did my hands the opposite.
Yeah, I was wondering.
Right. Yeah. So your baseline is north and south. Your townships are east and west. And the way you remember that, okay, is the T for township, cross the T, right? Left and right. Right? Baseline, the B, right? Up and down. That's how you can remember that. Okay, and they're each 6 miles apart. So it gives you that six square miles, right? For the 6 miles by 6 miles for the townships, right?
Yep.
Okay, they're numbered at the they begin being numbered at the baseline. The first strip north of the baseline is Township 1, north T1, right? T1 north. The first strip south of the baseline is Township 1 south, T1S. Townships numbers increase moving further from the baseline. The range is similar to townships, but running east and west of the principal meridian. And here's the diagram, right? So there's your baseline, there's your principal meridian. And then you have your ranges, right? 6 miles by 6 miles, east and west. And you have your baseline, right? Township 1 north, 2 north, 3 north. And they're all 6 by 6, right? 6 miles by 6 miles. T1 south, T2 south, T3 south. You good on that?
Yes.
Good. Okay, now locate, you need to know how to locate a particular section within a township and understand how to subdivide a section. Each township contains of 36 sections. You have to remember, a section is 1 square mile or 640 acres. A section, township, and range is how it's basically stated so you could find it. So like section 36, township 1S, R1W. Okay, so you look down here, you know, and you would find a section on the map, right? It would tell you, you go to section 36, you go T1S, R1W, boom, there it is, right? And then locating sections numbered in an S pattern beginning with the northeast upper right corner with section 1, subdividing the sections. Because you know, if it's 36 square miles, right? 6 miles by 6 miles, each section is 1 mile by 1 mile. So it's one, you know, it starts with 1, 2, 3, 4, 5, 6, 7, 8, 9. It goes in a snake pattern, right? Back and forth. So if you get a question, you know, what section is directly south of section 13? You got to, you know, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. So then you go 14, 15, 16, 17, 18, 19, and it's 24, right? You got to do it in your head. You got to kind of figure out where it is, right? So that's how you figure the section out. Now, you also have to remember how to subdivide sections. So here's your section, but then that section breaks down into 4 pieces. And then that breaks down into 4 pieces. And then that breaks down, and this is how you narrow down where the property is. And when you're doing the calculations, you know, you're going to take remember the 640 calculation, and you got to go by the denominator, right, to figure it out. So it's showing you 640 is divided into 4. So it'll be four of these 160s, right? And that gets divided into 4 40s, right? That's these here. And that gets divided into 4 10s. And then that 10 gets divided into 4 2.5s. You see how it keeps breaking down? And that's why you take the denominator and you figure that problem out. Like, I'm going to do one for you here. You got to remember how to calculate the number of acres in a partial based on the legal description and convert acres to square feet. Okay. So to find the number of acres in a tract, you take the 640, which is the number of acres in one section, and divide it by the denominator of each fraction in the legal description. So you take, if the example of the question is southwest quarter, northeast quarter, southeast quarter, and the northwest quarter of section 12, T3S R4E. None of this matters, right? What you need to know is it starts at 640, right? And divide by 4, divide by 4, divide by 4, divide by 4. So the correct answer would be, you take the math, you divide it by 4, it's 2.5 acres. Right? Now, you have to remember, if there's an and in the middle of the description, you have to calculate the acres on each side of the description and then add the total acres to get the correct answer. So example would be southeast quarter of the northwest quarter and the northeast quarter of the southwest quarter of section 21, T4N R5W. So you take 640 and divide by 4, divide by 4. And you take 640 divided by 4, right? And it gives you 40 and 40. Answer be 80. If this was a 2, it'd be 640 divided by 4 divided by 2, right? If it was a 6, it'd be 6. You know what I mean? It'd be whatever that number is on the bottom. Don't think it's always 4 just because of what we're doing here.
Got it.
Another number you have to remember is 43,560 square feet equal 1 acre, right? So in a section, if you have 640 acres, how many square feet would that be? You would have to take 640 times 43,560, and that would tell you how many square feet are in an acre, or in 640 acres, right? So you got to remember that, okay? The other thing you have to do is be able to explain the lot and block survey method and the use of the assessor's partials numbers. Okay, these numbers are used only where plat maps have been recorded. They're platted subdivisions divided into larger areas called blocks. Blocks are divided into lots, and lots are numbered. Okay, blocks are either numbered or lettered. Okay, now they have tax maps. Each parcel of land within a tax district is assessed for tax purposes. Each parcel is assigned a partial ID number. It's a PID number, partial ID number, or an assessor's partial number. PIDs are used to prepare tax maps. Okay, there's information used to prepare the tax roll so they can figure out who owes what, and they organize it all through these numbers. PIDs are sometimes used to identify a partial. So that you can actually, on some tax records, that tax ID number, you click it and that will identify the partial. Okay, they use that in accordance with it. Okay. Okay. Okay, now we're at Unit 11, which is one of the most important chapters, units of the entire class. 12% of your examination for the state will come from this. So you're going to have 12 questions out of 100 on real estate contracts. Okay, so let's list and describe the essentials of a contract. What is needed to make a contract, okay? A contract defines the parties' legal relationship and spells out each party's rights and duties. It's a voluntary agreement or promise between legally competent parties. There's an underlying in every contract is the promise. There's a promise of something. And it may assist buyers and agents and brokers. Our job is to assist buyers and sellers with completion of the 4 types of contract as directed. And then there's valid contract. A valid contract complies with contract law and contains 5 essential elements. The acronym is COLIC. So it has to have competent capacity of the parties. There has to be an offer and acceptance, which is the meeting of the minds, an offerer and an offeree, and the legal purpose of the object. There has to be a purpose. There has to be a legality of the object. It must be in writing and signed as per statute of frauds. And the consideration. There has to be a thing of value, a good given in exchange for some value, some other value back. Okay, now there are three types of contract to break them up. So there's a void contract, there's a voidable contract, and an unenforceable contract. You have to know the difference. So a void contract does not meet all the required elements of a valid contract and therefore has no legal effect. That's like if there's a signature missing or something's missing, if if the property description is not proper. You have a voidable contract. This allows one of the parties to potentially disavow contractual duties. This is like if you have a contract with a minor, somebody 17 or 16 years old. They can't sign a contract, right? They're not of legal age. That would be voidable. And unenforceable is a contract that will not be enforced in court because it does not comply with the statute of frauds or exceeds the time in the statutes of limitations. Okay, so that's the three different ways of voiding out a contract: voidable, void, and unenforceable. Now let's list the four types of contracts with which licensees may assist buyers and sellers with. So there's four contracts. We have a listing agreement for sellers, a buyer brokerage agreement for buyers, a sales and purchase contract, and an option contract. Now there's other addendum and there's other forms, but they're the four particular contracts that we have to use with our clients. So next, let's describe the effect of the statute of fraud. Okay, it requires contract conveying an interest in real property, and contracts that are not performed within 1 year must also says that they must be in writing and signed to be enforceable. And this pertains to purchase and sales contracts, option contracts, deed and mortgage instruments, leases for a term longer than a year, listing agreements for a term longer than a year, and buyer representation agreements for a term longer than 1 year. Now, next we need to be able to describe the effect of the statute of frauds. Okay, or I'm sorry, statute of limitations. Excuse me, I misspoke. Describe the effect of the statute of limitations. This is the time period set by statute during the term of the contract, during which the term of contract may be enforced. So written contracts in Florida law has a term of 5 years, and oral contracts, also called parole contracts, has a statute of 4 years. Okay. Now, you also need to be able to distinguish among formal, informal, bilateral, unilateral, implied, expressed, executory, and executed contracts. So formal and informal contracts. Formal is written. Historically, it was under seal. Not anymore, but it's written now and signed. And informal is oral, which is a parole contract. So formal and informal, written, oral. Bilateral and unilateral. Bilateral obligates both parties to perform. Unilateral obligates only one party. So a sales contract, a buyer and a seller have to perform. An option that would be bilateral. An option contract only requires the seller to perform. The buyer has an option, right? So that's a unilateral contract. The seller's obligated, the buyer's not. That's the example of those. Okay, express and implied. Express is an agreement between the parties, orally or in writing. Implied means obligations and conditions that are not stated but may be reasonably implied. Okay, so express is in conversation and in writing. Implied is like when the washer and dryer are hooked up and is hooked to the house and there's nobody saying they're not included. It's implied to think they come with the house, right? And executory and executed. Executory is an agreement involving promises to be completed at a future date. Executed means the parties have completed their obligations. So when all the initials and everything are done on the contract, that's executed. Everybody did their obligation. Executory means you have a verbal agreement, you sent the contract, you're waiting for them to initial off. That's executory. Once they initial off, it's executed. Does that make sense?
Yeah, it makes total sense.
Good. Now let's look at the various ways an offer is terminated. This is an offer. So it's wild card is our acronym. Okay. It could be withdrawn. If somebody puts an offer in, they can withdraw it. So withdrawal by offeror. So you send the offer, seller doesn't respond yet, you can withdraw it before they do. Insanity. If somebody's insane, like they're not right, they're legally insane. Lapse of time. You send an offer and they have till 5 p.m. to approve it. And that time passes, offer's dead. Death, if passed away. If they get a counteroffer, if the seller counteroffers them back, offer dies. Now you have a counteroffer. Acceptance is if the seller accepts it. Rejection if they reject it. And D is for destruction of property. So if there was a hurricane or a fire, earthquake, destruction of property. Now we have to be able to describe the various methods of terminating a contract and explain the remedies for breach of contract. So a contract is terminated when any of the following happens. BLIMP is our acronym. Okay. Breach, that's when somebody breaks it. Lapse of time, that means the time ran out. Impossibility of performance, so they're not able to perform. Something happened, they cannot perform. Mutual rescission, which is renunciation. So if both of them say, nah, we don't want to do it. And if they just don't perform. Impossibility of performance would be if somebody had a mortgage and they lost their job and the mortgage company is no longer giving them the mortgage, right? It's impossibility of performance. And performance just says, oh, I'm not doing it. I just don't want to do it, right? That's the difference. Okay. So I'm going to describe the 4 legal remedies imposed by the courts for breach of contract. So if somebody breaks the contract, there's 4 types of remedies. 1, there's something called specific performance. That is when a court orders a party who committed the breach to perform as stated in the contract. It's called relief in equity, and it's sought by the buyer seeking the other party to do what was promised. So if the seller says, hey, I'm not selling it, too bad, the buyer can take them to court, and the court can have them confine it and order specific performance. And then they have to do what they said. Liquidated damages. If a buyer defaults, the seller may retain the deposits as liquidated damages. Right? So liquidated damages are just that. You can't get any more, just that. Rescission is cancellation of the contract, and the parties are restored to original position. Buyer and seller both agree. They cancel it. They give the money back. No problem, right? Compensatory damages. This is unliquidated damages. So the money that you lost in the deal, you lost. But this is civil money if a seller or a buyer sues the other party, if there's more damages. So say the house came off the market, they didn't buy the house, the prices came down, they can sue them for more money, right? That's compensatory damages. Okay, so there are the 4 remedies for breach of contract. Now, let's differentiate among the various types of listings. Okay, so when you have a listing contract, there's different types of listings. Listing contracts may be written, oral, or implied. However, everyone's in writing that I do, because you can't prove any other one, right? You have an open listing. This is where 1 or more brokers are involved. The commission to the broker who sells the property. So a bunch of brokers can try to sell it. Whoever sells it gets paid. That's a unilateral contract. Okay. Exclusive agency listing. This is when there's 1 broker. The commission goes to the listing broker if it's not sold directly by the owner. So if the owner sells the property to somebody he knows, they don't have to pay you a commission. However, if you sell it or any agent sells it as it listed, you get paid. That's a bilateral contract. Okay, owner and agent signs that. An exclusive right of listing agreement. This is 1 broker. Commission goes to the listing broker no matter who procures the buyer. Seller brings the buyer, anybody. you still get paid. And this is a bilateral contract, seller and buyer. So, right? Good. All right. Then there's a net listing. Okay. A net listing is when a commission is paid on a net basis. It's an open, exclusive agency or exclusive right of sale listing can be structured as a net listing. This is where a seller agrees to sell a property for a stated acceptable amount. That's the seller's net. The broker will retain any proceeds in excess of the net. That's called a net listing. Okay. It's illegal in a lot of places. Florida, it's legal but frowned upon because there could be a lot of, misleading in that. It's like, there's a lot of profit that if somebody says, hey, I just want this much for the house, it's a little bit shady when you do that, and it is frowned upon, but people do them.
Got it.
Next, we need to be able to describe the elements of an option contract. Okay. An option contract is an agreement for the seller to keep open for a specific time and offer to sell or lease real property. The property owner is the optionor, and they grant the buyer, the optionee, the exclusive right to buy the property for a specified price and term within a certain period of time. Okay. It's a unilateral contract. The optionor, who the seller, is bound to perform under the terms of the option. The optionee is under no obligation to pay the buyer to buy the property or lease it. There's consideration for the purchase under the terms of the option. So there is a deposit put down by the buyer. It's held in escrow. The terms of the provision require terms and provisions require of a valid contract. So all the provisions to make it a required contract are still needed. Options are assignable unless prohibited in the terms of the agreement. So if the seller gives the buyer the option, that buyer can find somebody else and sell it to them if it's agreed. It can also be put in there where you can't do that. Okay. The licensee requirements. Okay. There's a substantial valuable consideration. They must put a substantial amount down in deposit for this to be effective. Okay. So now we're going to list and describe the information contained in a sales contract. You're going to have the names of the vendor and the vendee, the seller and the buyer, legal description. The consideration is how much they're going to put down as a deposit, the purchase price, financing, or if it's cash, the terms, the type of deed the seller will deliver, title evidence to be provided, expense and prorations to be paid, personal property if it's included, washer and dryer included, right? Things like that. Date, time, and place of closing. When the possession of the property will occur. You also need the spouse's signature if the property is owned by a married couple, tenancy by the entireties, or if the property is in a homestead and the ownership is in only one spouse's name. Remember that? When it's in one name, it's in severalty, but both spouses must sign because a homestead makes it a life estate, right? When one dies. Right. So let's explain and describe the various disclosures required in a real estate contract. Okay, there's a material defects disclosure. There's a seller disclosure we use. Okay, the sellers of the residential property must disclose material defects. Johnson versus Davis was a Supreme Court decision that decided that. The as-is provision does not circumvent duty to disclose. So the as-is contract, that doesn't mean it's as is and you don't have to disclose it. You still need to disclose. Okay, material defects concern the property and not its occupants. So if somebody dies in the place or somebody's sick or something like that, that does not need to be disclosed. However, if there's a leak in the roof and they fixed it and no one says anything, that had to be disclosed if you knew about it. Material defects concern the property, not the tenants, not the owners, right? Radon gas disclosure. This is the required radon disclosure statement on the sale and lease contracts. This is information regarding radon gas. It does not require testing for sale or lease. This is in the contract. Like when you have a contract, it's in there. It's all in the contracts. Lead-based paint. Residential Lead-Based Paint Hazard Act, Reduction Act. It's federal law. It applies to housing built prior to 1978. Sellers and landlords must disclose the presence of any known lead paint. Buyers and renters must be given an EPA booklet, which we have that. I'll show you that at a later time. Anytime you're showing property built before that, you have to give them a brochure, which it's emailed, and you document it. Sellers must allow buyers to conduct an inspection within 10 days. The inspection is not required, and the seller is not required to pay for it. If a buyer wants it, the buyer can pay for it and have it done. If the seller or landlord does not comply, a buyer or tenant who is harmed by the presence of lead paint may sue the seller or landlord. There are contractor requirements to remove it. Like there's protocol. Disclosure either as a separate document or disclosure may be incorporated into the sales contract or lease. On a sales contract, it's a separate form. In a lease, it's built into it, or for the ones I use. You have an energy efficiency disclosure. This is the Florida Building Energy Efficiency Rating Act. Buyers at the time of prior to signing the sales contract receive an information brochure stating the purchaser may get an energy efficiency ratings. It created a uniform statewide energy efficient rating system of new and existing buildings. And this rating system applies to public, commercial, and residential structures. Homeowners Association disclosure. A property subject to a mandatory homeowner association has a disclosure. They must provide the buyer with the disclosure regarding the association fees, restrictive covenants, and assessments, along with the HOA docs and all that stuff. Remember, when it's a resale, they have 3 days right of rescission, right? If it's a developer, 15 days, right? So they have 3 days right of rescission if not received before signing the contract. And this cannot be waived. You can't say, I don't want it. It's just part of it. However, if a buyer doesn't get it and the buyer closes on the property, it ends at closing. There's no repercussions. If they never got it, they never got it, right? It's not something that goes on past the closing, okay? Property tax disclosure is a disclosure summary concerning the ad valorem taxes before or at the time of execution of a contract for sale. Buyers should not rely on the amount of the seller's property taxes as indication of the taxes purchaser will be required to pay in the year following the purchase of the property. Next, we have a building code violation disclosure. The seller must disclose if there is an existence and nature of the violation. Copy of the pleadings notice, etc., have to be given to the buyer. The buyer will be responsible for compliance with code if they buy this house before these things are fixed. That transfers to the buyer. Seller must forward the name and address of the new owner to code enforcement agency within 5 days. Next, we have a community development district, the CDD. This is an independent special district. It serves the long-term needs of the community. It constructs, operates, and maintains infrastructure and services. The developer finances construction of infrastructure by issuing bonds. Homeowners repay the bonds through tax assessments. There's written disclosure in initial contracts for sale that these exist. Okay, so it has to be given to them. You know, I have a couple listed right now that have these, and that documents, and they're in the listing. They're in with the attachments. Okay, you have to recognize what constitutes fraud, misrepresentation, and culpable negligence. So misrepresentation is a misstatement, omission, or concealment of a factual matter. So you're misrepresenting it. Fraud has the 4 elements of cause of action, which we talked about prior. The licensee made a misstatement. The licensee knew the misstatement was not accurate. The party relied on the misstatement, and the party was damaged as a result. If those 4 elements are there, that constitutes fraud. Okay. Any questions? That's the end of Unit 11 for contracts.
No questions.
Good. Okay. Next is a pretty important chapter. 9% of the exam will be on residential mortgages. This is Unit 12. Okay, so what we need to know about this for testing purposes, you need to be able to describe the mortgage instrument and the promissory note. So there's 2 documents, mortgage and promissory note, right? The mortgage pledges the property as security, which is collateral for the debt. Hypothecation, you want to remember that word. Hypothecation is the process of pledging a property as security without surrendering possession. That means you could live in the house, but it's still secured. It's still being pledged, right? Just like when you drive your car, you have a loan on it. You're driving your car. Okay, that's hypothecation. They don't hold the car till you pay it off, right? So pledging of property for security without surrendering possession. It must be in writing to be enforceable, right? So it has to be written and recorded. It has to be recorded to establish constructive notice of the lien and the lien priority, right? So a mortgage must be recorded or it won't have any lien priority. The borrower, who's the mortgagor, receives the money to finance the property, right? So remember, borrower and mortgagor. There's two O's in borrower, there's two O's in mortgagor, right? Lender is the mortgagee. They provide the money and the mortgage instrument when recording. It creates the lien. So they provide the money and the mortgage. It gets signed. When it's recorded, that makes the lien. Okay. And then you could remember there's two E's in lenders, two E's in mortgagee. That's how you can remember if the question has that, you need to know that, right? Now that's the mortgage, right? That's your that's your collateral. If you don't pay, they take it, right? That's the collateral. Now you have the promissory note. So they work together. The promissory note's your promise to pay. The mortgage is what happens if you don't pay. So you break that promise, they use the mortgage to take the house, right? So the promissory note is a legal instrument that serves as evidence of debt. It proves that you have a debt. It's a promise to repay the debt. It makes the borrower personally liable for repayment of that obligation. The lender can sue the borrower for the remaining unpaid debt after a foreclosure. What that means, if you get a property foreclosed on and there's still 30 grand left, that fees and all that stuff, they will sue you and put a lien on you for the additional money after they sell the house. Okay. So it provides financial details of a loan's repayment. You have to remember, the note is where it tells you how much you borrowed, what the interest rate is, what the repayment method is, the term of repayment, and what happens if you don't pay. So all your loan information is on the note, not the mortgage, right? Because that's public. The mortgage is a public document. The note is not. So you have to remember the amount of the loan, the interest rate, all those things, the payment terms is on the note, not the mortgage, okay? And mortgage lien priority, that is determined by the order of the liens are recorded, by the order of the liens. So the first mortgage is to be recorded first. The date and the time of the day establishes priority over subsequent liens, right? So your first mortgage gets recorded first. If there's a second, it goes second, right? All right, so that's how that works. Now let's talk about a subordination agreement. You need to understand what that is. Okay, the priority of liens determines the order of the liens will be paid if the property is sold in a foreclosure sale. So if a property gets foreclosed on, the first mortgage gets paid first. The second, it goes in that order. Okay. The higher priority lien can be subordinated to subsequent liens if the parties agree. So if somebody has a higher lien, they can do a subordination agreement, let somebody go ahead of them. So a subordination agreement is used when a mortgage recorded earlier takes a lower lien priority to a mortgage recorded later. That's when that's used. Okay. So if you had a second mortgage, say you had a credit line and you wanted to refinance and get a mortgage and keep the credit line, that credit line would do a subordination agreement and let the mortgage go ahead of it. Is how that would work. That's an example. And then a satisfaction of mortgage. That is what happens once you pay it off. It's satisfied, right? Don't mix up subordination agreement and satisfaction. Satisfaction means you satisfied the mortgage, you paid it off. That's the release form. It's the release of the mortgage and it's recorded by the lender. So when you pay the mortgage off, they record that and they must cancel the mortgage and send the recorded satisfaction to the mortgagor, which is the owner, right? Within 60 days. It's the borrower. So they got it. Once it's paid off, they have 60 days to record it, remove the mortgage, and send you the proof. Recording the satisfaction of mortgage shows that the mortgage lien has been removed. That paper is what says it's been removed. You need that. Okay, now you need to be able to distinguish between title theory and lien theory. Okay, lien theory is Florida. Florida is a lien theory state. That means the borrower retains legal title to the property. So when you buy it, the deed goes in your name. The lender is protected with the lien, which is the mortgage. If you don't pay, they take the property, right? Title theory is where the title is conveyed to the lender through a mortgage deed or a trustee through a deed of trust. In those states, the borrower retains equitable title. Remember, equitable title is it's not in your name until you pay it off, right?
Yeah, it's gonna be in a future date.
Right. Now, however, equitable title happens when you have a second mortgage, like a seller holding the mortgage in Florida. Right? But any other time, it's lien theory, right?
Wait, can you say that again?
The only time equitable title is used here is when it's a seller holding the mortgage. Right? Remember, the seller holds the title until you pay them off, then they put it in your name after?
Is that on a seller finance?
Seller finance. Yes, exactly. Yep.
All right, thank you. Yeah, that's good.
The only time. Any other time is equitable title or lien theory. It's a actual title. Okay.
Got it.
Good. All right. So let's look at the next section here is we need to describe the essential elements of the mortgage instrument. So what are the essential elements of it? So in the mortgage document, there's going to be a prepayment clause. This will give you the conditions to repay the debt in advance of the due date. Okay. That says that prepayment clause will say you're allowed to pay it off at any time. You win the lottery, you want to pay it off, right? No penalty. Prepayment penalty clause means there's a penalty for early payment. So if there's a prepayment clause, that means you can. There won't be both of those. It'll be one or the other. Prepayment penalty clause says that there's a penalty for paying it off early. Acceleration clause, that's in there because upon default, that's what allows them to make all the debt due payable now. Right? Remember the acceleration clause makes all the payments due. And then if they go and pay the bill and fix it, it goes back, right? And the right to reinstate is when the mortgagor's right to reinstate the original payment terms after the lender has initiated the acceleration clause. So in there, there'll be a right to reinstate. It tells you in the mortgage, if you pay the fees before the auction, you have the right to reinstate it back to the original terms. That's actually in the mortgage document. Okay. You have a due on sale clause. So upon sale, alienation, right? When a property goes from one to the other, anytime a name changes, upon sale, the loan is due and payable. That means it has to be paid off when you sell it. Okay. And you want to remember a defeasance clause. Okay. You got to remember defeasance clause. You may see something on that. Okay. The lien theory is when the property is no longer collateral when a debt is repaid. In a title theory, the mortgagor receives legal title when a debt is repaid. So the defeasance clause tells you, is it a lien theory, title theory, and explains how you get your title. That's what the defeasance clause is. It explains the theory of title, right? Describe the various features of a mortgage, okay? So what are the features that are in a mortgage? You have a down payment, right? That'll be the money you're putting down at closing, the percentage down. A loan to value ratio. That's the relationship of the amount borrowed to the purchase price, right? So if you're putting a $20,000 down payment and the purchase price is $100,000, right? And your value is $100,000, you're going to borrow 80. That means your loan to value ratio is 80%, right? That's how that works. Equity is the monetary interest the owner has in the property over and above the mortgage indebtedness. The formula is the current market value minus the mortgage debt equals the equity. You have a $100,000 house, you put $20,000 down, right? Your equity is 20%. Interest. Interest is what the bank makes. That's their profit. Loan servicing. Loan servicing is the bank will have a company servicing the loan. They collect the payments, they pay the taxes, the insurance, they do all the servicing. Escrow account. Okay, that's the advanced monthly payments of property taxes and insurance. So you would have your principal, insurance, taxes, principal, interest, tax, and insurance. If you have PMI, whatever, then you would have an escrow account, which would take your taxes and homeowners insurance for the future, and it would divide it up, right? All right. So PITI is the month, like I just said, monthly installment of principal and interest. And if your property taxes and insurance are included, that's your PITI, right? Discount points is an added loan fee charged by lenders to increase the yield on lower than market interest loans. Loan origination fee is a charge for processing a mortgage application. Calculating the loan to value. You take the loan to value ratio, the LTV, okay? It equals the loan amount divided by the sale price, and it gives you the LTV. So if they tell you figure out the LTV, you take the loan amount, divide by the sale price, and boom, there's your percentage, right? Explain the use of discount points, okay? The cost to the borrower is based on the loan amount. Cost of each point is equal to 1% of the loan amount. Discount points are charged as prepaid interest at closing. The cost of the discount points is the calculation is you take the loan amount times the discount points charged, and that equals the cost of the points. So if you have a $100,000 loan and you have 3 points, that would be $3,000, right? Okay, now you also need to be able to calculate the yield on the loan. Remember the form, the percent increases the yield, right? So each discount point, if you bought 3 points, it costs you $3,000, right? As discount points. Now to figure out the yield, you got to take those same 3 points and multiply each one by the points 3 times 0.125, right? And that'll give you 0.75. And that'll be your yield increase, right? Then you got to take the whatever your rate is, add 0.375, and that gives you your yield on the loan for your APR. Do you see how that calculation works 2 ways? It's 1% to buy them, and then 0.125 for each one to figure out the yield. Does that make sense?
Yeah, it makes sense. I learned it another way that to me it just seems a little bit easier, and it's by dividing whatever the amount of points it is, dividing that by 8, and that will
because it breaks it up into 8. It's the same. It's the same.
Yeah.
It's just reverse math. Yep.
Yeah.
Yep. Okay. Good. And then explain assignment of mortgage. This is when ownership of a mortgage is transferred from one company to or an individual to another. That's when the mortgage sells from one bank to another or one investor to another. The payments don't change. The loan doesn't change. Just who you pay changes, right? Now let's explain the assignment, the purpose of an estoppel certificate, right? Estoppel certificate is a letter, and it's to stop a claim that the amount owed is different from the actual unpaid balance or the interest rate is other than what is the contracted rate. So when one bank sells a loan to another bank, they must do an estoppel letter. They must show what the original loan amount was, how much was paid, what the rate is. All that information has to be transferred with the loan. And it verifies the unpaid balance, the interest rate, and the date to which the interest has been paid prior to the assignment to the new bank. It's just documentation that they can't change. It's documented on paper with the transaction. Okay, that's an estoppel certificate. Next, you need to be able to distinguish among the various methods of purchasing mortgage property. So if you're buying a property from somebody and they have a mortgage on it, so purchasing property encumbered, that means there's a lien on it, encumbered by an existing mortgage loan. First, there's an assumption, right? You can have an assumed mortgage on VA and FHA. Very unlikely, very rare. Okay. Assumption of an existing mortgage. That's when the buyer executes a promissory note and becomes primarily liable for the debt. The seller will still be liable for the original promissory note if the new buyer doesn't pay. However, remember novation agreement? The novation agreement makes the new buyer solely responsible in the event of default and lets the original owner off the hook, right? Now, if a loan has a due on sale clause, that requires the debt to be paid in full when the property is sold. It does not allow for assumption. Okay. Then you have subject to mortgages. This is where the buyer is not personally liable for repayment of the debt. The buyer takes the title and the seller is still legally responsible for the note. So this is where you go in, somebody's having a problem, say, look, I'll buy the house. However, I want you to keep the note. I'll catch up the mortgage. You're 10,000 behind. I'll pay the mortgage. I'll keep paying your mortgage for you, but I'm going to buy the house and you keep the mortgage in your name. The lender has to approve that. The lender has to say, okay, you can't just do that. Because if you do that and there's a due on sale clause, guess who's coming for foreclosure as soon as that title changes?
Amen. The mortgagee.
Yep. Because the bank's notified as soon as the title changes. Okay, so now you have a contract for deed. This is a land contract. This is used to finance the sale when a buyer does not have sufficient down payment for traditional financing. There will be seller financing. So the buyer makes a down payment. The buyer makes monthly payments to the seller. The seller retains legal title until the debt is repaid. Buyer gets possession at closing and has equitable title until the debt is repaid. Then the legal title is conveyed. The seller is the vendee, the buyer is the vendor, and the buyer is the vendee. Okay, so the seller is the vendor, the buyer is the vendee. Then you have land development loans. These are used to fund the streets and the infrastructure for the developments. Then you have construction loans. Lender disperses the funds and draws as construction progress happens. It's short-term financing during construction. Now, when a builder has a blanket mortgage over a whole development, that's called a blanket mortgage, and it pledges the property. Say they have 100 lots, 100 buildings, they get one mortgage to build all that, and then as they sell them, they release them, right? There's a partial release clause. It releases the individual lots. So the development that I just sold the 2 units in, we closed one, that came off. Now next, we're closing one in a couple of weeks, that's going to come off for them, right? That's an example of that. There's a takeout commitment for permanent financing. If you're building a house, you do your draws, and then when it's done, there's one loan. It's called a takeout commitment, and you pay everything off at the end into one normal mortgage. That's called a takeout commitment. You have that prior to closing. That's all part of the loan, the construction loan. And there's a buy down, which temporarily lowers the interest rates. A lot of times now, these new developments, rates are what, 7-8% now? They're giving people 6% for 3 years because the builder is paying down the rate for 3 years. So you have a lower rate for 3 years to get people to buy them. That's called a buy down. Temporarily lowers the rate. Okay. Now I'm going to explain the foreclosure process to you. Okay. The first thing that happens is they don't pay the mortgage for so much time, usually 90 days or more. The bank files a lis pendens. Okay. That initiates a suit. Okay, so the lis pendens goes to court. Okay, that will initiate a suit on the promissory note. So they sue on the note, you're promised to pay. They obtain a judgment and then execute a judgment against any real or personal property. Okay, unless you're homesteaded, it's a different process. Like it's a little bit different because they can't take the personal property. Okay, initiate a foreclosure proceeding. Once they have that judgment, they start a foreclosure proceeding on the property subject to the lien. Okay, the lender accelerates the due date on the remaining debt, right? They use the acceleration clause right there. That's when they make it due. And then it goes to public auction. Okay, if you pay it off before public auction, you can reinstate it. If it goes to auction, that's it. It's gone, right? You have a short sale. A short sale is a transaction where the net proceeds at closing will not satisfy the payoff of the mortgages and other liens on the property. Seller is selling the home for an amount less than the amount owed to the lender and other lien holders. A short sale is subject to the lien holder's approval. The lender has to approve it. Okay, and then you have foreclosure on income property. Remember, the only type of foreclosure that has a receivership clause. Receivership clause allows a receiver to be appointed by the court to collect the income from the property. And that income will be used to make mortgage payments in the event of default. So if you're foreclosing, they'll take all the rental income and put that towards the mortgage on the property. What allows them to do that is the receivership clause that the court will name. Okay.
but that is as they are losing the property. So they're already losing the property regardless.
Well, once they file the list pendants and that order is given, it'll happen then when they start the initiation process of the foreclosure. Once that order is given, it'll be part of that order saying that there's a receiver name, and then they're going to collect the rents from that point forward.
Got it. Okay. I have a question. We're on page 70 right now, but I want to go back to page 68.
Mhm. Go ahead.
I think it was a stop will letter. I just want to double check if I have like a good thought on that. So with the stop will letter, essentially what it does is it's a letter that is done by a financial institution like a lender whenever they're selling the loan to another bank, another lender, and that just explains what the terms of the loans are, such as interest rate and all that good stuff, so that cannot be changed.
It's like a stop and
Uh,
it's like a picture in time, a stopple letter. From that second when that's recorded there, when they made that form, that's the numbers. They cannot change. That's what it is. That's
okay,
why they call it, it's like a stop of time, and it's right there. It's like a photo of what's going to them. It's proof of it.
got it. That's pretty much for the safety of the mortgagor, the
Yeah.
borrower.
Yep.
Got it. Okay, thank you.
Good. All right. And where do we start? Okay, so here. Now we need to distinguish between a judicial and a non-judicial foreclosure. Okay. So a deed in lieu foreclosure, they call this a friendly foreclosure because it does not involve a lawsuit. The defaulting borrower transferred the deed to the mortgage to avoid a foreclosure process. The lender takes a title and the property is subject to existing liens. So there's no court. You still get a foreclosure on your record and your credit, but there's no court, there's no extra fees. You're doing that so they can sell it or do whatever and not have extra fees, right? It's called a friendly foreclosure. Just give it back, right? Then you have a list pendants. Okay, that's the notice recorded in the public records of pending legal action involving real estate. There's constructive notice on pending legal action. So that means it's recorded, right? So that's how you know a property is being foreclosed on. That's how we get our list, right? It gets recorded, and the next day we see, oh wow, this property is foreclosing, right? It names the parties, the bank and the mortgager, mortgagee, the objection of the action, the object of the action, which is the property, and the legal description of the property. That's what's on the list pendants. Okay. Then we need to describe the mortgagors and the mortgagee's rights in a foreclosure. So equity of redemption, that's the right of reinstatement. A mortgagor can prevent foreclosure by paying the principal and interest due plus collection expenses. The right of redemption ends once the property has been sold at foreclosure sale. The doctrine of caveat emptor applies. So when you buy it at the sale, if there's any liens and judgments, you assume them. You got to do your own research when you're buying these, right? You can get stuck really bad. And the purchase is subject to any prior liens of record or interest for whichever there is constructive notice. Okay. So if there's any liens, you're now responsible. Okay. Do you have any questions on that section?
I do not have any questions in that section, no.
Okay. Right. Okay, now we're on unit 13, which is the types of mortgages and sources of financing. So we have 4% of the test on this for the state. You're gonna have 4 questions out of 100. And it's gonna explain, okay, so the first thing you need to do in this section is to be able to explain the process of qualifying for a loan. Okay, so the first thing done is there's a uniform residential loan application, URLA form, the URLA form. What it covers is the information for the people, the current and previous employment, monthly gross income, assets and liabilities, and their credit history. They do a credit evaluation and credit scoring. They verify their qualifying ratios to see how much house they can qualify for. They qualify the property, make sure the property is financeable. and they'll get a pre-approval letter or a pre-qualification. Okay, now you got to remember the qualifying ratios. Okay, you have to be able to calculate the qualifying ratios for different types of mortgage loan programs. All programs have different ratios. So you have the housing expense ratio and the total obligation ratio. Remember that on our practice exam? So the housing expense ratio is the HER, and the total obligations ratio is the THRU. The HER is the monthly housing expense, which is the principal, interest, tax, and insurance, and mortgage insurance. And you divide that by the gross income. Total obligation ratio is all the monthly obligations. That would be what the HER is, plus any other obligations, student, anything on your credit report, student loans, credit cards, car payments. And that would be divided by your monthly gross income. Now, for a conventional loan, the recommended HER is 28%. And the recommended THRU is 36%. FHA is HER is 31%, and the THRU is 43%. Cannot exceed those. And a VA loan, the THRU cannot exceed 41%. Now you see on a conventional loan, it's recommended. They can go higher. The higher they go, there's different programs and there's higher rates. However, for testing purposes, 28 and 36, okay? But these cannot exceed. These are fixed. You cannot go over them. If it's 43.0014, can't get it, right? Now let's look at this. Let's describe some of the features of a conventional mortgage. It carries no government guarantee or government insurance. The lender assumes the full risk. That's why the numbers are lower, right? There's more risk to these. The interest rate is negotiated between the lender and the borrower, and it typically includes a due on sale clause. That means it prevents assumption. Loan must be paid in full if closed. Prepayment clause. This allows the borrowers to prepay the mortgage principal at any time. And it usually requires a larger down payment. Okay. Now I'm going to describe the features of an amortized mortgage. A fixed rate mortgage consists of fixed equal monthly payments over the term of the loan. At the end of the term of the loan is paid off. They're usually 30 years and 15-year terms are common. They have 10, 20, 25, but 15 and 30 is usually the most common. It's also called a level payment plan mortgage, same payment each month. Okay. Now let's describe the features of an adjustable rate mortgage and including the components, how it works. So the interest rate can change at preset intervals. It's a 2-year arm, 3-year arm, 5-year arm, 7-year arm. Those are the intervals. You have the index, which is the economic indicator used to adjust the interest rate. It's not controlled by the lender. So that's prime rate. Whatever prime rate is, that's an example of that, right? The margin is the spread. That's the percentage added to the index, which is the bank's profit. So if prime rate plus 2, prime rate plus 3, prime rate plus 1, whatever that is, that's their profit. So the formula to calculate the rate is you take the index plus the margin, and that equals the calculated interest rate. You need to know that formula. Index plus margin equals calculated interest rate. Okay. The adjustment interval is determined in the contract. Interest rate caps. There's a periodic cap limit on how much interest rate can change per adjustment, and there's a lifetime cap. However, that cap limit, if it's higher than that, that doesn't mean there's not going to be negative amortization, right? So if your cap limit is 2% and the rate goes up 3% and you don't pay the extra money, you're going to have negative amortization every month when you make your payment, because that interest is still going to accrue. It's just there's a limit to what you pay. Payment cap limits, the amount monthly payment can increase per adjustment. However, like I just said, negative amortization can occur. There's a teaser rate, which is initially below the market interest rate. Like right now on an ARM, it's a little bit less than what your rate would be on a fixed, because they want to get you into that. They give you a better rate. And then hopefully the interest rate comes down for you, but it could go up as well. So next is to describe the characteristics of an FHA insured mortgage. Okay, FHA is a government agency within HUD. It functions as an insurance company. It insures mortgage loans made by approved lenders. The lender set interest rates and may charge points. Section 203B is what a fixed rate mortgage loan is called under FHA, a 203B loan. Okay, the features, the interest rates are negotiable between the lender and the borrower. FHA approved lenders may charge discount points. They are assumable. Okay, so if somebody wants to assume a loan, they must complete a qualification of the buyer assuming the loan. They must apply and get approved. There's no investor loans. That means you must live in the property. No prepayment penalty, so you can pay it off anytime. The down payment is a minimum of 3.5% cash investment. FHA sets the limits on the loan amount that can be borrowed depending on the average cost of housing in various regions of the country. Okay, there's a one-time upfront mortgage insurance premium. It's UFMIP. It's a one-time upfront that's due at closing. So there is a mortgage premium you pay at closing. Okay. Let's see. Okay, so FHA is going to set the limits on the amount that can be borrowed depending on the average cost of the housing in various regions of the country. So, for example, FHA loan limits are different in Miami than they are in somewhere in Idaho. It goes by the market, if the properties are higher or lower. Okay, there's a one-time upfront mortgage insurance premium, which we just talked about. That's paid at the closing. Okay, that premium. Mortgage insurance premium is paid on a monthly basis after that. So you have the one-time upfront premium, and then you have premium after that paid monthly. And it's added to the monthly housing expense for calculating qualifying ratios, like we talked about before. Okay, as for the appraisal, they must be an FHA-approved appraiser. The appraiser confirms whether the property meets HUD's minimum property standards, and FHA does not warrant condition of the home. Okay, the insured commitment is when a developer seeks FHA commitment to insure the mortgages on a planned project. So that's when the whole project gets approved for FHA loans. And FHA gives a conditional commitment to ensure the mortgage loans on the individual homes are built to those FHA standards to qualify for that. Okay. Okay, so now we're going to describe the common FHA loan programs. Okay, so the first-time home buyer program is a 203B. They have a down payment assistance program. They have a reverse mortgage program for elderly, and they have the renovation rebuild. That's a 203K. You can find a property that needs to be rebuilt and fixed, and they have a program that they do a subject to appraisal and all that, and they'll actually finance in the fixing of the home. Okay. Next, we have to identify the guarantee feature of the VA mortgage loans and the characteristics of a VA loan. So these are non-conventional loans. VA loans are made by private lenders and that are VA approved, just like the FHA are approved. They have to be approved by them. A VA guarantees a portion of the loan called the partial guarantee, and that covers the top portion of the loan, the top 20%, say. Okay, they must use the property as a primary residence. VA does not require a down payment. They get 100% financing. VA does not charge a mortgage insurance premium, so there's no mortgage insurance. Only veterans and unmarried surviving spouses of veterans and active military may apply. Eligibility is based on the period of active duty or the period of continuous service. VA has the power to make direct loans in areas where VA loans are not available through private lenders. So there's certain areas in the country that are not super populated, and there may not be a lender who approves VA loans. So they can actually lend the money directly. Okay, the loan may be used to purchase, refinance, or construct a 1 to 4 unit property with the veteran living in one of the units. The lender sets the interest rate, discount points, and closing costs, not the VA. It's negotiated. Okay, there's a maximum entitlement. The amount the government guarantees the lender will be paid in the event of default. There's a certificate of eligibility, and that states the amount of entitlement available to the veteran. You can reuse the entitlement. The VA, once a VA loan is paid off, the veteran's maximum entitlement is restated, and they can use again for a different property. Okay, loan limits. There's no maximum loan limit with full entitlement. However, they must meet the lender's requirement for insufficient income, credit and income. The loan origination fee is 1% charged to the veteran borrowers. And there's a VA funding fee. They charge a fee for it. And that funding fee has a sliding scale with the lowest fee charged to the first time VA borrowers. The second time you use it, the third time, the fourth time, as you use it, that fee goes a little higher. And that fee and that those expenses may be added to the loan and financed for the life of the loan. So you can get 100% financing and add those fees in if you choose to. And again, this does not require mortgage insurance. So even though they're borrowing more than 80%, they do not require mortgage insurance. Okay. So you have to, now let's distinguish among the various types of purpose-specific mortgage products. So you have something called a home equity loan. This is to finance consumer purchases, consolidate credit card debt, college tuition, and so forth. The interest is tax deductible if used to make home improvements. However, if you did debt consolidation on your credit cards, you're unable to write that off. Okay. Okay. Now, there's two ways to get this loan. You can get a fixed rate lump sum one-time equity draw. They give you the money, you start making payments, or you can get an adjustable rate, interest rate home equity line of credit, and that's like it's like a credit card, but your house is securing it. So when you have a balance on it, you pay. When you don't, you don't. But that's just like a credit card. It has an adjustable rate, interest rate, usually prime plus something, and it's a line of credit that goes up and down. Okay, a package mortgage loan. This is something that includes both real and personal property as collateral. A reverse mortgage loan, also called home equity conversion mortgage. Okay, these are available through the FHA approved lenders. Homeowners that are 62 or older can borrow against the equity in their home, and they can receive a lump sum monthly basis or a line of credit to receive that money. Okay. Now we need to talk about distinguishing among the primary sources of home financing. So remember we talked about depository lenders. These are intermediaries. Okay. These basically have deposit accounts, checking, savings, things like that. So you have savings associations. Okay. The bulk of the assets in residential mortgages and home equity loans for these guys. Commercial banks, they specialize in construction loans. And credit unions, they primarily handle residential loans and home improvement loans for their members. Okay. Then you have non-depository lenders. These are like your mortgage companies, like your Loan Depot, your Quicken Loans, things like that. Mortgage lenders are fully serviced mortgage companies. They do not accept savings and demand deposits. So there's no checking, savings, nothing like that. The package loans, they originate and sell them to the institutional investors and secondary market participants. Okay, they primarily originate VA and FH loans. However, they do conventional as well. Okay, next we need to describe the role of the secondary mortgage market. Okay, the secondary mortgage market is an investor market that buys and sells existing securities, and they have two objectives. The investor market that buys and sells the securities, they circulate the mortgage money supply, and they standardize loan requirements. They standardize loan requirements by requiring certain standards for loans they'll buy. If they won't buy loans outside of those standards, everybody fits into those standards so they can sell to them. Does that make sense?
Yeah.
Now let's talk about the secondary market a little more, about the agencies. So we need to be able to describe the features of the major agencies active in the secondary market. So you have Fannie Mae and Freddie Mac, right? They're the government-sponsored enterprises, GSEs, they call them. They're publicly traded corporations sponsored by the U.S. government. They operate in the secondary mortgage market, and they purchase 2/3 of all U.S. mortgages. Okay, so if mortgages ever go really bad, they're in big trouble, right? Fannie and Freddie set the guidelines for the types of loans they will purchase called conforming loans. They buy consumer mortgages and package them into mortgage-backed securities. Fannie Mae is the Federal National Mortgage Association, and that's the largest secondary market participant. Okay, FHFA, the Federal Housing Finance Agency, has supervisory responsibility. They purchase primarily conforming conventional mortgage loans from large commercial banks. They also purchase FHA and VA mortgage loans. And they issue the mortgage-backed securities, which are sold to investors. Freddie Mac is the Federal Home Loan Mortgage Corporation. FHFA also has regulatory oversight over these guys. They're the secondary market for conforming conventional mortgage loans purchased from smaller banks, credit unions, and savings associations. And these loans are pooled together and sold on the mortgage as mortgage-backed securities. Now, Ginnie Mae is a government national mortgage association. Okay, they provide a secondary market exclusively for government insured and government guaranteed loans. Okay, it's a government-owned corporation housed within HUD. Okay, now they're the only secondary participant backed by the full faith and credit guarantee of the United States federal government. Ginnie exists to solely guarantee the security of federally insured and federally guaranteed loans. All it does is guarantee them. It does not purchase mortgage loans from lenders. So the lenders pull the mortgages together and deliver them to a securities dealer. Security dealers sell the Ginnie Mae guaranteed loans and the mortgage-backed securities to the investors. Okay. Then you need to be able to know how to determine the signs and to recognize and avoid mortgage fraud. So the 4 areas you got to look at is, or 3 areas you got to look at is using a straw buyer. Sometimes someone will use credit for a purchase other than their own. A lot of times this is identity theft, or if they're doing something shady, you can't use a straw buyer. No documentation loans. This is where you would have to have a minimum credit score, but the loan is given without disclosing employment, income, and assets. This was made illegal after the crash. Red flags. Okay, this is what you want to look for is like inflated appraisals or incorrect purchase prices, people trying to sell a house for more, trying to inflate appraisals, things like that. Okay, that's all mortgage fraud. And mortgage fraud is a 3rd-degree felony in Florida. Okay. Now we need to describe the major provisions of federal laws regarding credit and lending. So you got to remember the Equal Credit Opportunity Act, the ECOA. That applies to all consumer and commercial credit without regard of type of credit. That can be credit cards, car loans, houses, everything. It prohibits creditors from discriminating in a credit transaction against a protected class based on race, color, religion, national origin, sex, marital status, age, and also receipt of income from public assistance programs. So if somebody's receiving public assistance, they cannot use that in the calculation of approving their credit. Now we have the Truth in Lending Act. Okay, it regulates what information lenders must make known to consumer credit. Requires disclosures about terms and costs and standardize how costs are calculated. And it applies to closed-end credit where funds are dispersed in full at closing and must be repaid in full by the end of the term. This includes residential mortgage loans, car loans, and it applies to open-end credit such as home equity lines of credit and credit cards. Okay, it does not regulate interest rates. Rates are determined by, the product and the people and negotiation. Regulation Z implements how the Truth in Lending Act is applied. Okay, that's the law. So the Truth in Lending Act requires a lender to provide consumers the truth in lending disclosure at the loan application and the final truth in lending disclosure prior to closing. They must disclose the annual percentage rate, right? That's the yield like we talked about and we calculated, full cost of the credit, total cost of the loan, the amount financed, the total payments, everything that is included. And it also made bait and switch advertising a federal offense. So bait and switch advertising now became a federal offense legally. Next, we have the Real Estate Settlement and Procedures Act, RESPA. Okay, this is regulated under the Consumer Financial Protection Bureau, CFPB. The disclosure of an amount and type of charges due at closing must be clear. You must disclose an advance estimate of closing costs and an information booklet. It attempts to eliminate kickbacks from vendors and closing related services providers. It applies to federally related mortgage loans secured with the mortgage on a 1 to 4 family unit. So if it's not a federally related mortgage, and if it's 5 units or more, this does not apply. Okay, the Truth in Lending Act and RESPA integrated disclosure rule, THRU, right? This is the new rule where they combined it and they shortened the forms. So THRU reduced the 4 separate disclosures into 2 disclosures requirements. One shortly after the loan application and one before closing. So now when you apply for a loan, you get a loan estimate. That is required from the lender at the application or within 3 business days after you do the application. And a closing disclosure is the lender is required to provide to the borrower at least 3 business days before closing a loan, buyer, of purchase or a refinance. Okay. So if you're closing your loan on Friday, you must get it to the client by Monday, and they have to have 3 days to review it, right? And that is the end of section 13. Do you have any questions on this?
I honestly do not. Honestly do not. Most of those things we went over pretty greatly already, and these have been pretty nice.
Good.
I'm finding a couple things that I need to refresh my mind on.
Perfect. Now we're going to go through Unit 14, real estate related computations and closing of transactions. You're going to have 6 questions on this, 6% of the test. This is some of the math questions, the debits and credits, right? So you got to be able to compute the sales commissions. Remember the problem we did, the practice test? So when you're doing sales commissions, you have the sale price times the commission rate, and that equals the total commission. Then you take the total commission, and whatever percent goes to the listing brokerage would be the listing commission. And then you take the, from that commission, the listing commission, then you would multiply the sales associate's commission, and that would give you the sales associate's commission. And the same thing, the percentage for the selling brokerage, that's the buyer commission, would go to that broker. And then that broker would take the commission percentage for their agent and pay the sales associate their commission, right? So to calculate the percent of profit or loss, given the original cost of the investment, the sale price, and the dollar amount of the profit or loss, right? You have to figure out how you get it. Now, do you remember, the profit is, when you want to find out the profit of the percentage made, you got to take the amount made on the sale divided by the amount paid on the sale, and that gives you the percentage of profit. So the hit is made divided by paid, right? And the loss is the amount lost on the sale divided by the amount cost on the sale equals the percentage of loss. And you can remember that by loss divided by cost. So if you're trying to find the percentage made, it's made divided by paid. If it's trying to find the percentage lost, it's loss divided by cost, right? Now we need to be able to define settlement and title closing. So a settlement statement is a document that summarizes the terms and conditions of a settlement agreement between the parties. The title closing is when everything is in order, the title company will prepare all the documents for closing and all parties will sign. There will be a list of documents for both the buyer and the seller. The buyer has, there's also some other documents, but the main documents, the buyer signs a promissory note, the mortgage loan documents, the title insurance policy, and the closing disclosure. The seller will sign a bill of sale, the deed, the loan payoff if they're paying a loan off. And after all the documents have been signed, they are recorded in the public records in the county where the home is situated to give constructive notice, right? Now let's list the primary steps of a closing, right? So you get a contract, you have a contract. The earnest money is deposited, okay? If there's a second deposit as per contract, that'll be put in too. They do a loan application. You go through the contingencies, the inspection period and all that stuff, and mortgage contingencies. Appraisals done by the bank, the loan gets approved. Survey and title is ordered. You have the inspections done. Any required repairs you get done. They do a home inspection. The buyer gets hazard insurance. The homeowner's insurance is put in place and binded. Closing documents are reviewed. You do a pre-closing inspection walkthrough. Buyers are informed of the amount that needs to be closed. They got to wire the money. And then the earnest money that's in deposit gets sent as well. And then you pretty much go to closing and you sign up and then your deal's closed. Okay. Let's talk about the prorations, the buyer's and the seller's expenses. Okay, you have property taxes that are paid in arrears, right? So if you live a year and then as of January, your taxes are due for the preceding year, right? So you got to remember, sellers' days are used to calculate prorations. Unpaid property taxes are entered on a closing disclosure as a credit to the buyer and a debit to the seller, right? Because the seller has to give the buyer the amount
Amen.
due for next year. Prorations always have the same dollar amount entered for debit and credit. So it's the same amount, debit and credit. They offset each other, right? Never different numbers. Items paid in advance, such as rent, you use the buyer's days to calculate proration because the day the buyer buys it is when the first day of rent they get. So calculations will assume rent is based on a monthly basis and rent is paid on the first of each month. So buyer's days are used to determine how much of the tenant's monthly payment belongs to the new owner, which is the buyer, as of the date of closing. Prepaid rent is entered as a credit to the buyer and a debit to the seller. Interest on mortgage loans are paid in arrears as well. When prorating an item paid in arrears, use seller days. So on an assumed mortgage, when you have interest on an assumed mortgage, it's entered this way: a debit to the seller and a credit to the buyer, right? Because the assumed mortgage, they still owe a certain amount on that, the debit to the seller. The buyer is going to start paying it next month. Okay, formula for interest on an assumed mortgage. You must take the loan balance, multiply it by the interest rate, and that gives you the annual interest. You take the annual interest, divide it by 365 days, and that equals the daily interest. Daily interest rate times days seller owns in the closing month equals the proration amount. That's the credit to the buyer, debit to the seller. Remember we had a problem on that on the practice test?
Yep, I remember that.
Good.
Let me ask you this. Now that I can do this, when something's paid in arrears, that means that thing is not paid in advance. Therefore, it's paid after it's used, essentially.
Right. So you're living the month, and then next month is due.
Okay,
Arrears. You're paying for the month behind you.
got it.
Huh? Okay, good. Okay, so the next thing we need to do is to calculate the dollar amount of transfer taxes on deeds, mortgages, and notes, and compute individual costs allocating the transfer taxes and costs to the proper parties. Now remember, on our math questions and our math review, all these are broken down step by step. So here we just go over it verbally. If you need to go over it again, the math review is where all that is, okay? I'm just trying to go over this again to get it into your head formula-wise, okay? Okay, you have state transfer taxes. State doc stamps, the state documentary stamp tax on deeds. Okay, tax paid on deeds and other conveyances. It's assessed on the full purchase price. It's assessed at the rate of 70 cents for each $100 of the full purchase price. 60 cents for each 100 if it's Miami-Dade County. Makes no difference whether the purchase is all cash, all finance, or mixed. The tax is entered as a debit to the seller only on the closing disclosure. Has nothing to do with the buyer. It's a one-time tax paid at closing, not paid annually. The way you'd figure this out is you take the purchase price, divide it by 100. It gives you taxable units. You round it up to the next whole number, and then you multiply it, right? Or I'm sorry, you divide it by the tax, and it gives you the partial units. Then you take the number of taxable units, and you multiply it by 70 cents. If it's Miami-Dade, 60. And that'll give you the cost of the documentary stamps on the tax deeds, okay? Then you have the state doc stamps on the promissory notes. Now, promissory notes is the buyer, right? They're getting the note. It's paid on all new and assumed promissory notes. You need to remember that. It's new and assumed. It does not apply to cash purchases. So if there's a cash purchase, this doesn't happen. The tax rate is 35 cents per 100 on the face value of the promissory note. It is an expense usually charged to the buyer. The reason it's usually, it can be negotiated that the seller pays it. Okay, but very rarely does that happen. A tax is entered as a debit to the buyer only on the closing disclosure. You take the promissory note divided by 100, it gives you taxable units. There's no partial stamp, so you round up to the next number. The number of taxable units times 35 cents is the cost of the doc stamps on the promissory notes, and that would be the tax paid. Then you have your state intangible tax on mortgages. This is paid on only new mortgages only, not assumed, right? So only new. The tax rate is 2 mils per dollar of debt. So 0.002 per dollar. This is also usually shows as a debit to the buyer on the closing disclosure, nothing on the seller side. Usually because they can negotiate it so the seller pays it, but very rarely does that happen. The formula is the new loan amount times 0.002, and that's the cost of the intangible tax. Okay. Now, we need to explain the rules of thumb for closing disclosure entries. Okay. The purchase price is entered as a credit to the seller, debit to the buyer. New purchase money mortgage is a credit to the buyer towards the purchase price. Debit to the seller reduces the money received at closing. That's on a new purchase money mortgage. That's when the seller is holding the mortgage, right? Now, if the mortgage is assumed by the buyer, the credit goes to the buyer, debit goes to the seller because it's reducing their money again. Okay? If it's a normal mortgage and the seller's not holding it, it's just a credit to the buyer. There's nothing to the seller, okay? So items credited to the seller is the total purchase price and prepaid items. They're the two things that get credited to the seller. Items debited to the seller would be the mortgages paid off, that reduces their cash at closing. Prorated taxes, that's paid in arrears and are debited in seller days. Mortgage loan interest and assumed mortgages. That's paid in arrears and debited in seller days. Prepaid rent is paid in advance. Debited days is owed to the buyer, right? So the days of closing goes to the buyer. Tenant security deposit is transferred to the new owner. State doc stamps on the deed. Broker commissions if they're employed by the seller. Title insurance, the owner's policy. Preparation of the deed. Seller's attorney's fees if they have one. All those fees will be debited from the seller side. Okay. Items that are credited to the buyer. Okay, so these items will be credited to the buyer. The earnest money deposit, like the deposit they put down, will be credited towards the purchase price. The new mortgage, which is credited towards the purchase price. Prorated property taxes, that's coming from the seller. Prorated assumed mortgage interest will be coming from the seller. Prorated advance rent will be coming from the seller. And security deposits will be coming from your deposit, whoever has the deposit, right? Items debited to the buyer, the purchase price. Title insurance for the mortgagee's policy. State intangible tax on the new mortgage. State doc stamps on the new and assumed notes. Recording the deed, recording the mortgage. Buyer's attorney's fees if they have one. Preparation of the mortgage and a note. All those items are debited to the buyer. Okay. That's the end of Unit 14. Do you have any questions?
No.
Okay. Okay, now we're at Unit 15, which is the real estate market analysis. 1%, one question on this on the state exam. Pretty quick section. It won't take us too long. Okay, so what you need to know here is you need to be able to describe the economic characteristics of real estate. Number one, it's immobile. The immobility of real estate, it's fixed. You can't move it. Land is indestructible. It's durable. Structures have long lifespans, but the land is indestructible. It stays. And real estate is unique. Okay, so it's non-homogeneous. Okay, two lots side by side are never the same. There's never two duplicate pieces. There's different elevations, different sizes, right? So we have to be able to describe the physical characteristics of real estate. So government controls influence the market through zoning, building codes, and taxes and monetary policy. Both direct and indirect influences happen because of this. There's a relationship between supply and demand and price. Okay. Supply and demand are continually adjusting, and it causes changes in price of real estate. The market is slow to respond to changes in the supply and demand. You got to remember that. It's not fast. It's slow to respond to changes. And the area of preference, the situs, is the place to which the purpose of legal jurisdiction or taxation a property belongs to. Okay. That's like what township, what area. Okay. You have to identify the factors that influence supply for real estate. The biggest factors are the availability of skilled labor, construction loans and financing, land and materials, right? So right now, loans are tough, right? Rates are high. They're very tight to get. Materials are a little expensive. Skilled labor is down. That all affects the supply. That's why supply is low. Okay. Identify the factors that influence demand for real estate. Number one is the price, right? Price of real estate. Change in price results in an adverse change in demand. If demand's down, like for a buyer's market, supply will exceed the demand. There'll be a lot more houses than people looking for them. Buyers will get a better price in turn. Seller's market is when the demand exceeds the supply. More people want less houses, right? Seller is able to sell for higher prices in that case. Okay, population numbers and household composition. Household is any person or a group of persons occupying separate housing space. The income of the consumers determine it. Availability of mortgage credit. Okay, that's a barometer of the real estate market. A small change in the rates creates a large change in the payment, monthly payment. In a tight money market, interest rates rise and demand drops. That's what we're doing now. Rates are up. People can't afford it. Remember, the house is like $1,200 more a month for the same house 6 months ago. You know, the rate change is so significant. I've never seen that where rates have gone 4% like in such a quick time. You have to be able to distinguish ways of interpreting market conditions and demonstrate understanding of the different market indicators. So the market indicators, you have the price levels of new homes and new number of building permits determines what's coming in the market. Vacancy rates, the percentage of available rental units that are not occupied. So if there's not many, it's a good market. If there's a lot, it's a slow market, right? And sales volume, the numbers of homes sold. You know, we're down 40% from last year. This time last year, 40% more homes sold in the same time of the year. It's a lot, you know. And that's the end of Unit 15. There are the things you need to know to keep in mind for this part of the examination. Unit 16 is 8% of the examination. You have 8 questions on your test from this part. So you need to be able to describe federal and state regulations pertaining to appraising. Okay, so the FIERA, the Financial Institutions Reform, Recovery, and Enforcement Act, that's what oversees it. And you have the Appraisal Foundation. And underneath that, there's the Appraisals Qualification Board and the Appraisal Standard Board. Okay, state certified appraisers. Okay, there's certified residential appraisers and certified general appraisers. They use the USPAP form, the Uniform Standards of Professional Appraisal Practice. Licensees may perform appraisals for compensation. Licensees must abide by the USPAP form. They cannot perform appraisals for federally related transactions. They cannot refer to themselves as a certified appraiser either. You got to remember, CMAs and BPOs, they do not comply with the USPAP form. They are not appraisals, right? We must describe the appraiser's fiduciary relationship. An appraiser must be impartial, not engage in criminal conduct, and be objective and independent, okay? They cannot deal with the seller, the buyer. They have to be, their fiduciary is to the bank, right? They owe the bank. Describe the Uniform Standards of Professional Appraisal Practice, the USPAP. It's a set of guidelines for appraisal services. It requires objective and impartial appraisals, establishes record-keeping requirements, creates confidential appraisal client relationship, which appraisal in the bank, right? Unethical to accept compensation based on value. Federally related transactions must be written to conform to USPAP. Also includes appraisals for Fannie Mae, Freddie Mac, FHA, and VA. Okay, all federally guaranteed mortgages. Okay, distinguish among value, price, and cost, and distinguish among the various types of value. So the concepts of value, remember we have a cost approach, price approach, or well, cost is the expenditure to create an improvement, the labor, the materials, and the land. Price is the amount paid. That would be the contract price. and value would be worth to many consumers at a certain time. So that house is worth this much to anybody who would look at it, right? Types of value. You have your assessed value. That's for property taxation. You have your insurance value. That's for replacement costs due to catastrophic events. Investment value is what an investor would pay based on a rate of return. Liquidation value is forced or rapid sale. Going concern value would be on income producing properties. Like what's it going to do going forward? And salvage value is at the end of the structure's useful life, when it's going to be torn down. Okay. Next, we need to define market value and describe its underlying assumptions. Okay, the most probable price a property should bring in a competitive market and open market under all conditions requisite to a fair sale. It assumes that the buyer and seller each act prudently and knowledgeably, and the price is not affected by undue stimulus. That's like if they're going through a divorce or have to sell it fast, anything like that. Assumptions in market value. The value applies to a specific date when the title is transferred. The buyer and seller are typically motivated. Both parties are well informed or well advised, acting in their own best interests. A reasonable time is allowed in the open market. Payment is made in cash in US dollars or in comparable financial arrangements, and the price is not affected by special financing or a seller concession. You have to distinguish among the principle of value. So what are the characteristics of the value? Demand. Is the property in demand or out of demand? Utility. Is it usable? Right? Is it used for the purpose they're using it? Scarcity. Is it very unique or is there many of them? And transferability. Is it sellable? Right? Can they buy it? That will determine the value. Now you have increasing and decreasing returns. Okay, when an over improvement occurs, when an owner invests more money in a structure, then the owner can reasonably accept the recapture. That's when they overdo the house, right? Make it too nice. Conformity. Are the houses similar? Are there many like it? Are they all looking the same? You have assemblage and plottage. Remember, assemblage is the combining of two or more lots and adjoining them to increase the usability and value. And then plottage is the increased value resulting from that assemblage. Remember we talked about that?
Yep.
Progression and regression. Okay. And then you have sales comparison. Let's first, before we go to sales comparison, what we have to do is we got to be able to differentiate among the three approaches to estimating the value of property, right? So remember we went over the different approaches: sales, income, and cost approach.
Yeah, we did.
Yep. So sales comparison, vacant. This could be vacant lots in an established neighborhood, single-family dwellings. Value is estimated by reviewing recent sales of comparable properties, called comps, and they're similar to the subject property. Sales must have occurred recently in the same market. Comparable properties must be similar to the subject property, and adjustments are made. So for transactional differences, there's changes in market conditions since the date of the sale. Financing terms. So an appraiser will adjust each comparable for special financing terms like seller paid points, conditions of sales. The appraiser must research for abnormal pressure on the buyer or seller. Then you have market conditions. The appraiser adjusts sale price for each comparable if market has changed since the comparable sold. Square footage. The appraiser adjusts the sale price for each comparable based on whether the square footage is larger or smaller than the subject property. Landscaping. Appraiser will adjust the sale price for each comparable based on the quality of the landscaping. So the property differences is, say, the location, the square feet, and so forth. Okay, if the comp is better, you subtract. If the comp is inferior, you add, right? You never change the subject property. The comp has to come down to the subject or come up to the subject, right? Okay. Income approach. This is for income producing properties. So the types of income, remember you have your potential gross income. That's the annual income if fully rented, no collection loss. Effective gross income would be the potential minus any vacancy and collection losses, plus non-residential income, which is the washing machines, the vending machines. And that's your effective gross income. And then you have your net operating income. That'll be your effective gross income minus any operating expenses. Okay, and that's going to throw off your cash flow. Let's talk about operating expenses. There's 3 types of expenses that contribute to operation of property. First, you have your fixed expenses. That's your property taxes, insurance. You have your variable expenses, maintenance, utilities, supplies, etc. And then you have your reserve for replacement. That'll be for allowance for future replacement of building components, roof, air conditioning, water heaters, things like that. You got to remember, not included in operating expenses is depreciation, cost of mortgages, personal expenses, income taxes, and any expense that does not contribute to the operation of the property. Okay, they're not included in operating expenses. Then you have your cost approach. This is for newly constructed houses, to cross-check other approaches, and for special purpose properties, right? A big library, a big building that is very unique, a church, right? A knowledgeable purchaser will pay no more for a property than the cost of acquiring a similar site and constructing an acceptable substitute structure, which is called the principle of substitution. The maximum value can be measured by determining the cost to acquire an equivalent site and to reproduce a structure as if new, and subtract subtract for depreciation, right? That's the 27.5 years, the 39. Remember how we did that? You have to estimate the value of a subject property using the sales comparison approach. Each comp sale is adjusted for the difference between the comp compared with the subject. Each comp is rated in terms of similarity to the subject. Rating is reflected in giving weight to each comp. The weighed comp determined the indicated value using the sales comparison approach. Remember how that one question was 30%, 40, and you had to break down each part and get the number?
I think I remember.
Yeah, remember gave you the comp values and what percentage each one was like?
Oh, yeah. Comparable A, this percentage, I remember that.
Estimate the value of subject property using the cost approach. So the cost approach formula is estimate the reproduction cost. Okay, you get the reproduction cost. Cost to duplicate the structure exactly. Then you have replacement costs. Remember, this is one to make it similar, but not exactly. Cost to build the same structure for use and function, but not exact copy of materials. And the estimate cost used using comparative square foot. The comparative unit or unit comparison cost estimation handbook. You have the handbook that gives you the estimations per square foot for what it is, and the cost estimate based on current cost to construct the building of same size, design, and quality. Number 2, you subtract accrued depreciation to derive depreciated value of the structure. The accrued depreciation represents the loss in value between the subject and the exact new replica. Land is not depreciated, right? Land never depreciated, just the property to construct, just the structure. A defect is curable if it is cost effective to correct. Okay, increase in value is at least equal to cost to correct. So if it's going to cost you more to fix it than it's worth, then it's not curable, right? Types of depreciation. You have physical deterioration. That's loss in value due to ordinary wear and tear, caused by use, lack of maintenance, and exposure to the elements. Functional obsolescence. This is loss due to operational inadequacies, poor design, changing tastes. They don't like that type of home anymore, right? Over improvement is also functional obsolescence. Then you have external obsolescence. This is loss in value due to something outside the property lines. Remember, if they put a recycling plant across the street, it's going to change the value of the property, right? It's going to hurt you. Good. Now you have the age life method. The majority of appraisers take into account the observed condition of the subject property. Based on a ratio of the property's effective age, that means the age indicated by the structure's condition and utility, to its economical life, which would be the total years the structure is profitably useful. Okay, that doesn't mean the house is 100 years old. It can be in perfect condition 100 years old, right? It depends on what it's rated, right? Accrued depreciation formula. Remember, you have to take the effective age divided by the total economic life, and that'll give you the reproduction costs new. Okay, and that equals the accrued depreciation. The alternate accrued depreciation formula is reproduction cost new divided by total economical life, and that'll give you annual depreciation. You take the annual depreciation, multiply it by the effective age, and it will give you the estimated total accrued depreciation. And it'll tell you that's how much comes off. Then you add in you estimate the value of the land, and you take the land value to the depreciated value of the structure, and that'll give you the indicated value. Okay.
Did we do it in an example of that one?
There wasn't an example. I mean, it's like if the reproduction cost, there wasn't really a math example for this. You're not going to see a calculation like this, but this here would be like, say your reproduction cost is $100,000. Okay, and your economical life is 30 years. So you take $100,000 divided by 30 years, and that'll be your annual depreciation. So let's just say your annual depreciation is $2,000 by 30 years. The total accrued estimated could be 2,000 times 30 years. You'd be able to accrue maybe $60,000 would be the total over the time. And then you would add the land to it. So let's just say it was 60,000, you add the land, say the land's 40,000, it's $100,000. You would just add that into the calculation.
Got it. Okay.
Yeah. There wasn't an example of this on the exam stuff, no. But it's just you just got to know how to calculate it.
All right.
Okay, and then estimate the value of subject property using the income approach. Remember the I over R plus V?
Yep, I remember that.
Right. So I is net operating income, R is cap rate, V is value or sale price. So rate times value equals NOI, NOI divided by value equals rate, NOI divided by rate equals value. So you always put the I over the line and then R plus V, right? R times V. And then you cover the one that you want, and there's a problem, right? To calculate it. Okay, reconcile the three approaches to establish the final value estimate. So reconciliation of the final values. The appraiser gives weight to each approach value, usually a percentage. The appraiser who used all three approaches for a single family house may give higher percentage to sales comparison approach than the other two. Actual sales of comps are better indicators of the property's value than the other two. Okay, then you also have to be able to calculate using the gross multiplier analysis. Remember the gross rent multiplier? How we figured that out in the ratio and multiplied it?
Yep.
So the gross rent multiplier is the ratio between a property's gross monthly rent and the selling price. The gross income multiplier uses annual income. It includes income from rent and other sources. The estimated gross monthly rent for the subject property. You calculate a market-derived GRM by taking the sale price of comparable properties and dividing by gross monthly rent. So you take the sale price divided by gross monthly rent, and that'll give you the gross rent multiplier. You calculate the average gross rent multiplier from several comps. You multiply the gross the gross monthly rent of the subject by the gross rent multiplier to estimate value of subject property. So the monthly rent divided by the market area GRM will give you estimated value if you want to turn those comps into rentals, right? Like we did on that problem. Next, we need to be able to explain how to prepare a comparative market analysis, CMA. Comparing and contrasting with the sales comparison approach. Licensees prepare CMAs to help buyers and sellers make informed decisions, not an appraisal report. Three major categories of comparables are recently sold, currently on the market, and recently expired. Recently sold shows you values they're worth, like closing. Currently on the market is what people are asking. And recently expired usually means they were overpriced or some problem with the property, right? Okay. Now we're going to go to Unit 17. Real estate investment and business opportunity brokerage. There's 2% of the examination on this unit. So you're going to have 2 questions of 100 that you're going to see on this unit. Okay. Second here. So you need to be able to define key investment terms. You have appreciation. That's the increased property value over a period of time. Assets, entire resources of a business. Cash flow, total amount of spendable income generated from investments. Leverage, use of borrowed funds to finance an investment. Liquidity is use of borrowed funds. Liquidity is to sell quickly without loss of capital, to be able to sell it quick and get your money, right? Get out of it. Real estate's not really liquid, right? Stocks are. Give me an example of that, right?
Yeah.
Basis is the investor's original cost of the property. Capital gain or loss, that's the difference between the adjusted basis and the net selling price. A tax shelter is advantages of owning real estate investments, because they're actually tax shelters because of your depreciation and other items. Real estate investment trust, they're called REITs. Okay, the opportunity to invest in income producing real estate as an investor, not as involved in it. And risk is the chance of losing all or part of an investment. Okay. So you need to be able to distinguish among the different types of real estate investments. So residential is single family and multi-family rentals. Okay. This part here is not about the 4 units or more, right? This is just explaining it's either single family or multi. Commercial is retail and office properties. Industrial is manufacturing and distribution. Agriculture is what people mostly purchase as an investment for future growth, long-term investment. These are more like farms and horse farms and places to grow vegetables and fruits. Business opportunities are interest in business enterprises or opportunities. They can be sales or leases. And there's also something called a goodwill of existing business, that you're buying the reputation, right? You have to be able to identify the advantages and disadvantages of investing in real estate. So advantages are rate of return, tax advantages, hedge against inflation, leverageability, and equity buildup over time. Disadvantages are illiquidity. It's the lack of liquidity, right? You can't sell it quick, right? Market is local in nature, so that affects locally. Need for expert help. Need for active management. If you're not there running it and operating investment property, you need somebody to manage it. And there's risk of losing some or all of your investment. Let's distinguish among the various types of risk. So business risk. The question is, will the income be sufficient to pay the expenses? Financial risk. Risk of defaulting on borrowed money. Purchasing power. Inflation risk. That's what you're running into right now, right? Prices, inflation, it's affecting the market. Defaulting on borrowed money. You have people that can't refinance because the payments are going up so much they can't qualify, right, for these commercial buildings. Interest rate risk. We're living it right now. Liquidity risk associated with a quick sale if you need to sell it fast. Safety risk. Loss of invested capital. Market risk is a decrease in market value resulting from increased interest rates. Risk of default is the risk of the investment will not generate enough income to sustain itself. There's a lot of that going on right now. Describe the similarities and differences between real estate brokerage and business brokerage. So some of the similarities are there's a sale of real property or an assignment of long lease in both. And they both require active real estate licenses, right? There's no different license, right? One license for everything. Differences. Business brokerage assets may include personal property and goodwill when residential doesn't. Going concern value may differ. And there's a wider geographic market. You're selling a business, there's a wider market to buy that than there is for residential, right? Describe the types of expertise business brokerage requires and distinguish among the methods of appraising a business. So first of all, when you're doing business brokerage, you need to know corporate finance. You got to understand how to evaluate corporate stocks, securities analysis and valuations, management of working capital, budgeting. You need to be familiar with business accounting, income statements, balance sheets, cash flow analysis, asset depreciation, taxation. Also valuations of businesses, comparable sales analysis, cost approach, income analysis. Liquidation analysis. Remember, that's only used for businesses going out of business, right? If you see a question, liquidation analysis is when it's going out of business, right? And then the steps in the sale of a business. You have to list the business for sale, identify all the assets, valuations, deduct the liabilities, valuation of stock, legal compliance with the laws, make sure that all the EPA and all that stuff is good, depending on what it is. Market and advertise it, secure a buyer. Buyer's got to sign a confidentiality agreement before you go over everything with them. Show them the numbers, right? Enter in a contract with the parties. Establish a due diligence period, closing preparation, coordinate a closing date, right? And that is the end of section 17. All right, so let's go into section 18. This will be taxes affecting real estate. There's going to be 3% of the exam on this section. There'll be 3 questions pertaining to taxes. Okay. All right, so for this section, you need to identify it and be able to discuss the city and county property taxation process. So basically for the real property taxation process, there's an ad valorem tax, and that's based according to value. That's what that means. Ad valorem is based according to the value. It's levied on a calendar year basis, and it's paid in arrears, right? So 2023's taxes become due January 1st, 2024, right? 24 will be due January 1st, 25, right? Okay, now the tax becomes a lien on all real estate January 1st. The lien is legally superior to any other lien, regardless of the date. Taxes are due on or after November 1st each year, and the taxes for the previous year that became due January after April 1st become delinquent. So you must pay them before April 1st or they become late. Okay. And now they have a couple different values. Okay. They have when they're assessing. There's a just value, and that's an objective valuation. The assessed value is established for tax purposes. And every year in November, October, November, property owner will get a notice of proposed property tax. It's called a trim notice. And that tells them how much the taxes are going to be, what it is, how it works. Now, if the taxes go up and you don't agree with it, you can appeal it. And a lot of people right now are going to be appealing it because there's a lot of things going on, right? So you have to contact the county property appraiser and you appeal to the value adjustment board. That adjustment board is 2 county commissioners, 1 school board member, and 2 citizens of the county. So it's 5 people. Okay, there's litigation. So it goes into court and you file a suit against a property appraiser and tax collector is the process. Okay. You also have to be able to distinguish among immune, exempt, and partially exempt property. So immune property from taxes is government properties, right? Government properties don't tax themselves. They're immune. Exempt properties. These would be like nonprofit organizations that own and operate real estate for religious and charitable purposes. And also they're subject to taxation, but not released from taxes. So they get a tax bill, but then they're exempt. They waive it, right? They still get a bill. They're not immune, but they get a release from it. And then there's partially exempt. That's taxed on only part of the assessed value. And that's like homestead and things like that, right? Okay, so now let's describe the various personal exemptions available to qualified homeowners of homestead property. So you have the homestead exemption. To qualify for the homestead exemption, you must be a permanent resident of Florida, and you can only claim 1 homestead. You must hold the title to the Florida homestead residence in your name, can't be in a company. As of January 1st, hold the legal title and reside in the home. The first year, you must file the county property appraiser before March 1st. So as long as you close on the house before the end of 2023, you can file for homestead before March 1st, 24. If you close on it in January 24, you can't file until January next year, right? Because there's only that time period. And remember, if it's under 25, you get 25,000 off each. 25 to 50, you get the base 25 on each. If it's 50,000 to 75, you get the 25 on county and city, plus any prorated additional. And then 25,000 only on school, right? Because school's always 25, right? And if it's over 75, you get the 50,000 to 50,000, and then 25,000, right? On the school board. Now, let's look at the additional exemptions. Okay, it's 5,000. It's no longer 500, right? This was before. As of January 1st, 23, it was 5,000. So for surviving spouse, widower, not remarried, if it's a remarried widow, no, you don't get it. Unmarried, right? Legally blind, non-veterans who are totally and permanently disabled get 5,000. Okay, 100% homestead. Totally and permanently disabled quadriplegic, totally and permanently disabled first responders also applies to the spouse. Disabled veterans, if they're at least 10% disabled, 10 to 99, their service-connected misfortune, they get 5,000 extra. If they're 100% disabled, okay, and it's service-connected, totally disabled veteran, it includes a surviving spouse, they pay no taxes. And then the surviving spouse of a veteran who died while on duty, no taxes, right? You got to be able to compute the property tax on a specific partial, given the current tax rate, assessed values, eligible exemptions, and transfer of assessment limitation difference. That's to save our home's portability. Remember, we talked about taking that to the new house, right? So you have the cumulative homestead exemption. That's the taxable value is determined by totaling all the tax exemptions that apply and deduct from the assessed value. Tax rates are expressed in mils. That's 1,000%. Remember, move the decimal point to 3 places to the left. So you take the taxable value times the tax rate, and that equals the annual property taxes due. Okay, so some facts about calculating property taxes. Homestead exemptions are deducted from the assessed value to find the taxable value. The base $25,000 exemption subtracted to calculate the school board taxes. Non-homestead property, the assessed value is the taxable value, right? So if they're not homesteaded, whatever it is, multiply it, right? The taxable value is multiplied by the tax rate in mils to determine the property taxes. The Save Our Home benefit, right? Save Our Home. It caps the assessed value of the home's property that it may increase per year. The just value of the homesteaded property may increase by a lesser 3% or CPI price index for the preceding year. The Save Our Home benefit is difference between the assessed value and just market value. Homeowners may transfer up to $500,000 of SOH benefit within 3 tax years of the last qualified exemption. Okay, so if they sell a house, they buy another one in 2 years, they can take that over. Okay, describe the purpose of Florida's Greenbelt Law. The Greenbelt Law allows the property appraiser to assess agricultural land based on the current character and use. They don't base it on what it could be, right? Because the tax would go through the roof. The assessment is based on current use, not based on highest and best use. It protects farmers from high taxes because land may be suitable for commercial development. Requires annual classification as agriculture. So you have to refile it every year to get the classification. So calculate the cost of a special assessment given the conditions and amounts involved. So you have one-time taxes for public improvements that benefit the property owner. That's like the street paving and the sewer lines. Remember the problem we did with the street paving? That's a special assessment.
Yep.
It's not a superior lien. It's not an ad valorem tax. It's levied on a front foot basis for street paving or a per hookup basis for sewer lines. Okay, lot dimensions are written with frontage first and then the depth of the lot second. So you take the front feet times the cost per linear foot, and that gives you the total paving cost. The total paving cost times the property owner's responsibility, and the proper owner's responsibility divided by 2 sides of the street, right? Describe the tax advantage of home ownership. Deductions if tax payer itemizes. So you can take your mortgage interest on your principal home and second home, property taxes on your principal home and second home, they're tax deductible. First-time home buyer has an option to withdraw money from an IRA without penalty. Exclusion of gain from sale. If you're single, the first $250,000 profit is free from tax. And if you're married, the first $500,000 is free from tax. Interest on home equity loans are deductible, provided loan is used for home improvements. Mortgage origination and discount points is deductible in the year paid. Refinance points are deductible over the life of the loan. So if you're buying a house, you write off all the points. If you refinance it, it's broken down over the years of the loan. Okay. Now you have to explain how to determine taxable income of investment real estate. So you got to know the types of income, the effective gross income, and then the net operating income. The formula for effective gross income, you take the PGI minus vacancy and collection losses and add other income. That's the EGI. Formula for net operating income, you take the EGI minus the operating expenses, and that equals net operating income. Okay, then you have deductions from gross income for investment properties. Okay, so you have your operating expenses. That's your replacement expenses, but not your reserves. You have your financing expenses. That's your mortgage interest. You have your depreciation. That's the deduction of cost improvements. You have your depreciation for income tax. That's depreciable basis. Remember, land is not depreciated. And your straight line depreciation is 27.5 years for residential property, and that includes single family, condominiums, and apartments and townhouses. 39 years for non-residential income producing properties, and that includes industrial and commercial investment property. Okay, 39 for commercial, 27.5 for residential, right? So distinguish between installment sales and like-kind exchange. So formula for depreciable basis. Step one, you take the total cost to acquire the property minus the value of the land, and that's your depreciable basis. You take the depreciable basis divided by the useful life, 27.5 or 39, and that's your annual IRS depreciation deduction. Remember we did that on one of the practice tests?
Yes, yes.
20% off and divided by 39, right?
Yep.
Like-kind exchange. This is real property for real property. The reason it's called 1031 is that's the section of the IRS code. It's section 1031. Any personal property or money exchange to even out values is called the boot. Boot is subject to taxes on the receiver. Remember, say it was $1 million and they bought something for $950, that $50,000 would be taxed. That's the boot, right? Other capital gains is a profit from the sale of real property. Taxable gain is determined by the amount realized from the sale, which is the sale price less expenses of the sale. That's your commissions and all your fees. The adjusted basis is the owner's original cost plus expenses of purchase and capital improvements. And then the capital gain is the amount realized less the adjusted basis. So whatever you made minus the adjusted basis, and that'll be your capital gain. Capital loss is if you lost, right?
Yep.
And that is the end of section 18. Okay, so we're going to finish up unit 19, the final unit of its planning and zoning. You're going to have 1% of the exam, one question on your state exam from here. And then once we finish this, I'll go over quickly the appendix and all the extra information we have at the end of the document for you to review and have for your records. So the first thing with planning and zoning, you need to be able to describe the composition and authority of the local planning agency. So the composition of the planning commission, it's a diverse group. They're appointed, they're not elected. It's a voluntary position that is unpaid. They have an advisory board. They are advisory board to the elected officials of the city or the county on what ways to go with decisions. So they advise them. The authority of planning commission, the city planning commission often gives final authority on subdivision plat approval, site plan approval, and sign control. Then you need to be able to describe the purpose of the land use controls and the role of zoning ordinances. So zoning is basically what makes up zoning is it's local laws that implement comprehensive plans. And it's the exercise of police power to regulate. And they do that by permissible use of the lands, the lot size minimums, types of structures, building heights, setback requirements, and density levels. All of that helps them control the land. So you need to be able to calculate the number of lots available for development given a total number of acres contained in a partial, the percentage of land reserved for streets and other facilities, and the minimum number of square feet per lot. So you very likely can see a question like this. So the formula for buildable lots in a tract, okay, you have 1 acre equals 43,560 square feet. So you got to take 43,560 times the percentage of available for lots, and then equals the square feet available for the lots per acre. At that point, you take the square feet available for lots per acre times the number of acres in the tract, and that'll give you the total available square feet. You take the total available square feet divided by the minimum square feet per lot, and that's how many buildable lots you get in the tract. We did a sample problem like this before, right? And it broke it down to so many lots per tract, right?
That's right.
Good. You got to be able to distinguish among the 5 general zoning classifications, zoning ordinances, building codes, and health ordinances. Okay. You have residential zoning that regulates density, and subcategories establish minimum lot size, and it limits the number of units per acre. Other zoning classifications are the commercial regulates intensity, which would be traffic. They have buffer zones, which is a strip of land separating one use from another. Industrial will regulate intensity. Agriculture, and then you have special use, which are government properties. That'll be your classifications. Then you have your building codes. Okay, these are to protect public health and safety from inferior construction practices. There's minimum standards for materials and quality of workmanship, sanitary equipment, electric wiring, and fire prevention, and so on. Okay, there's a statewide Florida building code, which is R values, wind loads, codes enforced by local government. So R values will be for insurance, wind loads will be for building and the roof attachments. The codes are enforced by local governments through building permits, building inspections, and certificate of occupancies. So when you want to build something, you get a permit. You build it, they come inspect it. And then once people want to move in and it's ready and livable, you get a certificate of occupancy. Then when they check everything. Okay, and then you have to remember, you have developments of regional impact. They're DRI zones. This is any development that, because of character, size, and location, will have substantial effect on the health, safety, and welfare of citizens of more than one county. There's statewide guidelines and standards. These include shopping malls, shopping centers, attractions, and sporting facilities. Disney, where they play football, baseball. These are big developments that affect more than one county. Okay, they're called DRIs. And then you have to explain the purpose of variances and special exemption and a non-conforming use. So zoning board of adjustment, there are types of appeals and requests for relief if something doesn't fit into the criteria. You can get a variance. This permits minor deviation. Usually there's a hardship related to the land use, and the board has established criteria for handling these items from the past. There's a special exception. This is separate use for a specific partial. You can get an exception to put something somewhere if they allow it. Legally non-conforming use. This is what happens when there's a change in zoning code that caused a property to no longer conform, and they're grandfathered in. So this is a property that no longer would be able to be opened in a location. However, it's been there, and since the change, it's grandfathered in. Okay, that's legally non-conforming use. You also need to describe the characteristics of a planned unit development. That's a PUD, planned unit development. It's special zoning use. There's clustered homes. It's a higher density, and then there's green spaces between the clusters. This is like a typical development. There's mixed land use. You have single family homes, multifamily housing, which would be townhouse and apartments. And some of them even have retail locations and office locations built in them. Okay, there's also planned open spaces and parks and things like that. This would be a PUD, a planned unit development. You have to understand the basic provisions of National Flood Insurance Program. So the National Flood Insurance Program, the NFIP, Insurance is available to owners, tenants, and businesses if a community participates in the NFIP. Participating communities agree to adopt and enforce ordinances that meet FEMA requirements to reduce risk of flooding. It's administered by FEMA. The insurance is purchased through insurance agencies. So FEMA is in charge of it. They run it. They administer it, but it's purchased through insurance agencies. That's how they sell it. Flood insurance rate maps. Remember, you can look them up online. FEMA prepares flood insurance rate maps. They're called FIRMs for every city and county in the United States. They identify flood zones on the firm as low risk, moderate risk, and high risk. High risk areas are identified as special flood hazard areas. They're located in 100-year floodplains. The high risk flood hazard areas are A zones on the firm. High risk coastal areas are coastal land located in the special flood areas, and they're notified by being zone V on the firms. So buildings built in V zones must be elevated, anchored to protect against impact of waves, hurricane force winds, and erosion. Okay. Then last but not least, we need to explain the various environmental hazards associated with real estate. You have asbestos. That's a mineral fiber that was used up until 1978. Radon, it naturally occurs. It comes from the ground, from limestone. It's a gas that causes cancer. Lead-based paint is used before 1978. Mold, there's many types that are harmful to humans, but there's many types that aren't. But mold can be an issue. Water supply, you have private wells and septic systems. You also have public water and sewage, right? So you need to have the stuff checked out, make sure there's no problems. And wood destroying organisms, that's like termite inspections and like things of that nature. Okay. There are some of the environmental hazards that you deal with real estate. And that brings us to an end of chapter 19 or unit 19. This is the complete Cram course that you needed to review for your exam.